Good morning. This is the Colorado Energy and Carbon Management Commission. It is our Wednesday, October 9th meeting, and we will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Here.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ogletree, Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
All right. Good morning. Seems like we just saw each other. We've been doing a lot of work here recently via Zoom. That was on the cumulative impacts and enhanced systems and practices rulemaking, which will start up again tomorrow morning at 9. Today, we have a regular business agenda in which we take up business of the Energy and Carbon Management Commission. Before we take that up, we try to give the commissioners an opportunity to inform each other of things that may be happening in their spheres of commissionership. In that regard, do we have any commissioner comments? Fair enough. We've all been working really hard. Next up is consent agenda. Do we have any questions on consent? I would note too that there is 1 or 2 hearing officer recommendations as well. Seeing no questions, do we have a motion to approve consent?
So moved.
Do we have a second?
Second.
Motion and a second on consent agenda for approval. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye. All right. We've got a loaded docket today, ladies and gentlemen. We start with docket 2301-00006, a variance request by TEP Rocky Mountain as the applicant. And then we have a petitioner, Loves Travel Stops and Country Stores. Could we bring up Mr. Jewell and whomever else he may have with him for presentation purposes? And then I also think we need to bring up Mr. Owen for Loves Travel Stops and Country Stores.
Mr. Jewell and Mr. Owen have been elevated.
Mr. Jewell, entry of appearance.
Good morning, commissioners. Michael Jewell with Jewell Jimerson Natural Resources Law. It'll just be myself presenting today. I do have Jeff Kirtland, who is available for questions afterwards. So I don't know if it is the pleasure of the commission to swear him in now. I don't want to speak for Mr. Owen, but I think he has a client witness as well with the same posture.
Mr. Owen, entry of appearance on your behalf.
Yes, Brent Owen with Haynes Boone on behalf of Love's Travel Stops and Country Stores, Inc. And I do have Steve Walters, who's a real estate project manager, available to answer questions, but we don't plan to have any presentation.
All right. And the way I see the agenda set up is we've got a presentation from TEP, a presentation from Loves, and then commissioner questions. Does that sound accurate, or is there anything procedurally ahead of time before we move into the presentations? Mr. Jewell?
Sounds accurate to me, sir.
Mr. Owen?
That sounds good to me. Thank you.
Mr. Jewell, you're recognized. We'll get to swearing in witnesses if we get to questions for witnesses. How's that?
That sounds great, sir. Thank you. Good morning, commissioners. Michael Jewell again with Jewell Jimerson Natural Resources Law on behalf of TEP Rocky Mountain LLC. We thank you again for your detailed diligence, as said before, with the cumulative impacts rulemaking. I guess I like to say this is a welcome respite, but I think despite the heading of this docket number 2301 Quad 6 as a variance, I hope I can prove from the thoroughness of the application and the steps taken. Indeed, it just might be. And TEP requests a detailed variance from you today, as your materials show, but one that I think should earn your approval since TEP has demonstrated a robust parallel compliance. It's backed by the director's recommendation, her staff's recommendation. It's supported by our petitioner who's here today, and it is, I argue, founded within the principles of undue hardship of the statement of basis and purpose for Rule 502C3 for the granting of variances. And lastly, it's supported by the relevant case law that we cited in our application. And I'll be brief as possible in our case in chief, and I'll be your guide today this morning, but I'm joined, as we said before, by Jeff Kirtland in case you have any detailed or technical questions afterwards in your deliberative process. So TEP became aware of a Love's Travel Stop location to be built immediately adjacent to the PA 217 in the summer of 2022. That truck stop would share a landowner, and TEP and Loves have been in discussions and mitigations to protect the PA 21-7 wells throughout the process. Given the fact that the truck stop is now open, the wells are currently operating successfully, and TEP has taken appropriate and necessary measures to mitigate and ensure proper oversight and operation of the PA 21-7 wells. TEP believes this variance request is proper and submits it for your consideration and approval. I'll refer you to the application for the details, the bulk of which I'll review here, but happy to address any further details that come to your mind when we get to that deliberative process. So to that end, the relief requested by this application is for the T&T Associates Ltd. PA 21-7 location. For the record, that's location ID 420224. It's located in Township 7 South, Range 95 West of the 6th Principal Meridian, Section 7, Lot 2. It's about 34.6 acres. The crossroads are Interstate 70 and County Road 300 in Garfield County. It produces from the Parachute Field from the Williams Fork Formation. The PA 21-7 pad consists of 15 producing gas wells, began producing in 2011 and continue to produce today. The request is for relief in two different buckets: from compliance from rules 602F, 602K, 606A, 610F, 610G, and H for the continued operation of the location due to the construction of the Love's truck stop in proximity to the location. This is all straight from the director's recommendation. In the second bucket is relief from the compliance with the rules 1002C, 1002F, 1003, and 4 for the lands where the Love's truck stop is now constructed, which were formerly part of the location but no longer. The relief of the applicant is seeking is not ministerial in nature, because we're here before you now, and that it required ECMC subject matter experts to review the content for the potentially permanent impacts that will have to be managed by the landowner and administered not from you any longer, but from the local relevant government. I note overall there are no objections by the director or her staff. Both the compliance unit and the reclamation unit reviewed the variance regarding the respective rules that TEP seeks a variance for the location. During their review, staff requested and received additional documents and revisions to the application that contributed to the support of this recommended variance. There are 4 sections that I'll now review in some detail. So the first one is kind of long, so I'll go over everything that TEP did to mitigate in preparation for this variance. So staff required a commitment that identified tasks would be implemented. These substantial tasks include, and are mostly highlighted in the application, confirming that all wellhead components met design specification, servicing wellhead valves quarterly to ensure proper sealing and operation, moving chemical injection point on wellhead to one side of a tree, allowing a wing valve to be closed, reducing a potential leak point, reducing trim size on dump valves to limit gas flow in, removing ruptured discs from separators as an unintended leak point, increasing frequency of optical imaging leak surveys of the location to monthly intervals, adding jersey barriers around wellheads to protect the external impacts from trucks or other vehicles, installing a privacy fence between the locations to limit outside access to the facility. TEP will verify that the Love store does not have a cathodic protection that could interfere with the facility CP. And TEP posting signage stating no smoking or open flame within 100 feet of the wellhead. Furthermore, to mitigate a release, the following tasks were identified and were implemented. We converted wellhead valves to automatic pneumatic fail-close valves that will be closed during a shutdown event. This moves isolation of the well to the wellhead from production units, providing protection of the flow line. We added gas detection, particularly around wellheads and production units, that would detect a 10% of LEL gas concentration. We developed shutdowns for each well based on historic flow and pressure trends, and shut well inflow conditions that fall outside. And we installed check well on gas header to prevent backflow from pipelines if a leak occurred on location. The above release detection and mitigation related equipment represented an investment of approximately $450,000 that TEP immediately invested ahead of the variance request and without regard to any necessary legal, bonding, or other associated costs that are required for this variance that are necessary to protect public health and safety. And we realize that economics do not bear into the equation, but we just want you to know that we do the right thing regardless of what is required. That's all number 1, but 2, 3, and 4 pretty quick. Number two, an updated stormwater management plan for the location. This was worked in conjunction with Loves and submitted for review to ECMC staff, which they found satisfactory. Number three, concurrence for additional financial assurance to bring in replacement topsoil that was lost during the construction. More on that with the conditions of approval. And number four, that a hazard analysis or a what if scenario would be conducted. And we did that, and it involved all of TEP's technical and regulatory staff. We hired a third party to conduct that what if scenario, and that involved some cost, but also some time that was I would call it a retreat, but you bring all your staff together for some time. That was good teamwork to go over the risk management and kind of brainstorm everything that could go and make sure that we review and assess everything that could go wrong with this type of scenario and make sure that's all documented. So it's a good planning exercise. So ECMC staff therefore recommended approval and provided conditions that TEP has either already fulfilled and or will gladly accept. So it's four really quickly. Number one, within 45 days of approval, TEP shall provide additional financial assurance of $132,975 for the cost of importing 1,773 cubic yards of additional equivalent topsoil to the location, and that needs to be a similar grade for the Piceance Basin of agronomic quality, and that will pass muster under Rule 1004A. Number two, the entire location will be fenced in addition to the proposed privacy fence that we identified in our application. Number three, within 45 days of the approval, the operator will provide a Form 45 to confirm the new post-variance location size and GIS shapefile. We would do this in the normal course of business anyway, so this is gladly received. And lastly, that a Form 4 will be submitted that documents the order, all the material details. And we have all this, frankly, ready to go and in place, and we'll be happy to comply. So thank you, commissioners. This is what we have for this to present to you. Again, TEP believes this variance request demonstrates what an operator can do to prove safe operations in the face of proximate challenges. And with your variance approval, TEP intends to continue to safely operate under this increased safety standard. And with that, we welcome your questions and deliberations.
Thank you very much, Mr. Jewell. Commissioners, we could do questions for Mr. Jewell now, or we could hear Mr. Owen and then kind of have questions for both. I don't have a preference. Does anyone have a preference?
I think,
Mr. Ackerman? Commissioner Ackerman?
Mr. Chair, it makes sense to me to hear both first.
That's kind of what I was thinking. Mr. Owen, do you mind going ahead and making your presentation?
Not at all. Thank you. And I'll be very brief. As mentioned, my name is Brent Owen. I'm with Haynes Boone. I represent Love's Travel Stops and Country Stores, Inc. in this proceeding. With me is Steve Walters. He's a real estate project manager for Love's. He's available to answer any questions folks might have. He's familiar with the variance application, the underlying and parallel litigation, and essentially, as explained in our response in our filing to TEP's amended variance application, Love's does not oppose TEP's request of relief. Love's disputes some of the factual representations that are best addressed in the context of the parallel litigation, but none of those disputes change Love's position or Love's belief that TEP's variance should be granted. Love's has no reason to dispute TEP's assurances that the requested variances will have no adverse impact on public health, safety, welfare, and the environment or wildlife resources as required by the rules. Now, I'm happy to answer any questions. Mr. Walters is happy to answer any questions. And otherwise, Love stands on its submission. Appreciate y'all's time.
All right. Thank you very much, Mr. Owen. Commissioners, I believe that the panel is open for questions. Commissioner Ackerman?
Thank you, and I appreciate the presentation and the materials that were submitted. I'm struggling a little bit with understanding the variance from 602F, which is the director being able to order a safety shut-in. Can you help me understand? The rest of them seem to be associated with, traffic in and out of the Love's facility, which makes sense. I don't know why we wouldn't want the director to still be able to order a safety shut-in if conditions warrant. And so can you explain why you're pursuing that variance?
Yes, sir, Commissioner Ackerman. Thank you for that. I guess we want relief right now from saying there's an imminent shutdown now. If circumstances were to change, we're not suggesting that the director couldn't order that if the circumstances change. But as the circumstances are today, given all of the changes we have made and all the safety parameters that we have implemented, we want to essentially assure that a reset has been done. And under those parameters, there would not be an order to shut down or shut in based off of these parameters.
Commissioner Ackerman.
Thank you. So I'm just trying to play that out in my mind, what that would look like. And so if the director does in the future recognize that there is a safety issue and order a shutdown, by your statement just now, does that mean that you might have an opportunity to argue that due to the safety measures that you placed, that there wouldn't be an opportunity to order a shutdown? Or as what I'm hearing is if the director in the future believes that there's a reason to do a safety related shutdown, that option would still be available.
If I could work a hypothetical to answer your question, sir.
Great.
Let's suppose there's a new director, and if that person is looking at these facts anew and would say, this is a non-standard location that is new to me, I would want to order a shut-in because maybe I'm looking at this setback and I'm not comfortable with it. I would want to have this variance as to that rule in place because you commissioners have looked at this and have said, well, we heard Tara and we saw that all these safety measures have been in place and we have recognized that this is a safe location. Now, if something materially would change as to this location because of Tara or Loves that would change the scenario as it is today, of course, we believe the director has that right to order a shut-in. But we believe as it stands today, regardless of what director is in place, this is a safe location and we should have relief from the rule as the location is at the moment.
That helps me understand your point. Thank you, Mr. Jewell.
Thank you, sir.
Further questions for the panel? All right, I'm seeing no further questions. We move to deliberations. Does anyone desire to initiate deliberations and or make a motion? Commissioner Ackerman?
Thank you, Mr. Chair. I recognize the conditions of approval as stated in the director's recommendation, and I would like to make sure that we clarify in the documentation the point that was made by Mr. Jewell that the 602F variance has to do with conditions as they stand and us determining this is a safe facility at this point. But if conditions should change that would require a 602F director safety shutdown, that option still remains available. With that clarification and including the COAs, I would make a motion for approval when the time's appropriate, unless others have things to say.
I believe we can consider that a motion on the table. I would second the motion, and now we have an opportunity for questions or deliberation amongst ourselves. I would look to AAG Davenport to ensure that he feels comfortable that the motion accommodates the points made by Mr. Jewell that the 602F variance is based upon current circumstances and does not foreclose potential action items in the future if things were to change.
Thank you, Chair. I'm clear on the motion. I think it was well stated. So I don't have any further questions or clarifications.
Okay. Commissioner Oath?
Thank you. And Commissioner Ackerman, thank you for raising this. It was what was concerning me as well. I like the way that you stated that. And I just to make sure I understand what we mean by, if circumstances change. Because as I've thought about this, it could be that there are physical things that change, but it could also be, I think what we're trying to say is, I think what Mr. Jewell is saying or requesting here is that the director will not order a shut-in because of while Terra is in compliance with the variances, which I think is appropriate. But beyond that, I don't think a variance from 602F makes sense. So it's basically like, as long as they're in compliance with what has been agreed to under the conditions of this variance, that would not constitute grounds for a shut-in. But we are making some assumptions here that the additional or variable actions and conditions that TEP is committing to are equally as protective as the underlying rules themselves, which, if that bore out to not be true, may warrant a reason to do a shut-in. So I just want to make sure that in that kind of a case, we're not saying that, the director would not be able to do a shut-in if, these conditions turn out to not yield safe conditions.
Mr. Jewell, do you want to respond?
Yes, sir. Thank you. Commissioner Oath, that's correct. I mean, I think 604F here is a clear mandate for the director to wield the power of the commission as to safety, public health safety here. So we're not saying that this variance would obviate that power to protect safety. We're just saying, I think reset is probably the right word. We're saying this variance gives us a reset because we do have that parallel evidence that we have provided safety with these protective measures. So I don't think using Loves as an example here, but like with what we have reset with Loves now as our neighbor, if we had another third party incident come in and that had a new safety threat, well, of course, that injection would be a new time to review safety, just like any other location existing in Colorado would have a new time for the directors to assess, is there a safety threat here where I need to exercise that power under that rule? I think, of course, the director would have that power. That is a new time to review whether or not that shut-in power would have to be used. I just mean for now, if you grant this variance, we're looking at this location as a new reset. So that power would not be used backwards in time, if you will.
Commissioner Oath?
Thanks, Mr. Jewell. I appreciate that. And that kind of a hypothetical totally makes sense to me, right? Another location comes in and new circumstances such as that. I guess what I'm wanting to make sure I understand and I'm in agreement with is if the changed circumstance is just new information about the sort of agreement here, right? So I think if granted, it's the other parts of the variance request, it's sort of with this expectation, assumption, understanding that what you all are agreeing to is equally as protective. If we get new information that makes us or the director question that, I guess what I'm saying is I would consider that to be a changed circumstance that would allow the director to take action.
Commissioner Oath, that's fair. And I think I can respond to that confidently because it's been a little over 2 years now. If there's new information, we'd love to hear it as well, because these are good wells despite their relative age from 2011. They're still producing nicely. We want them to continue to produce. That's why we've invested in them to make sure they are protected and they are safe, and we have all manner of ingress and egress, and that they are going to be, good neighbors in this area. I doubt there's going to be new information, but yes, if there would be new information, that would be outside of this variance. We want to make sure that that power is maintained, but also that we are remaining in compliance. That's what Terra does on a day-to-day basis, and we want to make sure we are good partners with the commission and with all of our proximate neighbors as well.
That's helpful. Thank you.
Ma'am, thank you.
Further questions for the panel or further deliberation on the motion? Seeing no further deliberation, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries unanimously. Thank you both, gentlemen.
Thank you, commissioners. Appreciate your time.
Thank you. Thank you for your time.
All right. We now will take up our next docket 231100348. This is an oil and gas development plan that we've heard in the past, and we continued it for some additional information. It is entitled the MDS Energy Development LLC, and I believe we're going to hear from Ms. Jost. Do you have any witnesses, Ms. Jost?
Yes, good morning, Chair. We do have a few that are joining. We're just bringing our original panel back in case there were any additional questions outside of the informed consent matter we'll present on today.
Is there anybody new, or are they all part of the original panel?
Nope, all original panel. Thank you for asking, Chair.
AG Davenport, are you comfortable that they've been sworn in previously on this docket and all those tenets of testifying truthfully remain, or do we need to re-swear?
I'm comfortable as long as all the witnesses were here and present to hear that. Miss Jost, is everybody in the
Yes.
meeting right now?
Yes, I see Neil Duncan, Justin Dunn, Joaquin Kandaki, Jim Jacobson, Andrea Gross, Rich Sade, and then Kelsey as well. So yes, everyone is here.
Okay, so I'll just reiterate in case none of the witnesses heard it. The witnesses should be aware that as this is a continued matter, they are still under oath and will not take the time to swear them in again.
Great. All right, Ms. Jost, you are recognized.
Okay, wonderful. Thank you, Chair. Let me go ahead and share my screen. Okay, Chair, are you seeing that okay?
Yes.
Okay, wonderful. Thank you. Well, good morning, Chair, Commissioners, staff, and members of the public. My name is Jamie Jost, and I, along with my partner, Kelsey Wazelinki, represent MDS Energy Development, LLC, in this MDS Energy 8-59 Oil and Gas Development Plan and continued docket number 2311-00348. Thank you for the opportunity to present this application again to you this morning. As a friendly reminder, the MDS Energy 8-59 Oil and Gas Development Plan requests approval of a 1,391.27 acre oil and gas development plan and corresponding drilling and spacing unit to allow up to 7 new horizontal wells to be developed from 1 new oil and gas location in the oil and gas development plan boundary. MDS has been planning the 8-59 oil and gas development plan for almost 2 years, with 333 days of that time pursuing this OGDP application with the Commission. The original informed consent was on the ECMC informed consent template, and that was obtained in March 2023. The WOGLA permit was filed in November 2023 after the informed consent was obtained. The OGDP application was filed in November 2023. The WOGLA was approved in March 2024 and recorded as a vested right in May of 2024. There were no public comments and no petitions received in May or June of 2024. And the director issued the recommendation for approval with 2 conditions of approval that MDS has already agreed to during our August 7th, 2024 hearing. At the August 7th, 2024 hearing, the Commission heard the OGDP application with respect to the substantial evidence provided in support from MDS and had several questions regarding the original informed consent obtained by MDS. MDS is back today to request approval of the OGDP application and to provide confirmation that MDS obtained an updated informed consent from the residential building unit owners, as well as an updated director's recommendation confirming the director's position that the updated informed consent meets the rule requirements and should be considered under 604B1. The MDS OGDP application has met the criteria and requirements for an approvable OGDP and the Form 2A permit. MDS Energy submitted each of the required Rule 303, 304, and 308 documents, and the submission was confirmed by the director's Form C certification of completeness. At the August 7th hearing, MDS provided substantial evidence the proposed oil and gas development plan is applying over 50 best management practices to MDS's oil and gas operations, and those BMPs will protect public health, safety, welfare, environment, and wildlife resources in accordance with the ECMC regulations and applicable law. The MDS Energy 8-59 OGDP oil and gas location only meets 1 alternative location analysis criteria, and that is Rule 304B2B Romanet I, with 1 residential building unit within 2,000 feet of the working pad surface of the proposed oil and gas location. There are 0 high occupancy building units, school facilities, or child care centers within 2,000 feet of the location. There are 0 designated outdoor activity areas within 1,500 feet of the location. There are 0 proximate local governments. The location is not in a floodplain or Rule 411 defined zone or public water supply. It's not in or upgradient of a riparian corridor. It's not within high priority habitat per rule at the time of the application submission, and it is not within a disproportionately impacted community or a cumulatively impacted community. MDS is not using a surface owner bond as it owns the surface of the proposed location. MDS's thoughtful and critically planned development is illustrated by the fact that only 1 out of 10 ALA criteria applies. Based on the commissioner's deliberations and the motion to stay this application at the August 7th hearing due to concerns with the informed consent, as well as the director's updated recommendation, MDS has revised its presentation today to only focus on the support of its approvable OGDP application under Rule 604B1. We do have our subject matter panel of experts available at the end of this presentation to answer any questions on the OGDP application that may not be addressed during this original hearing or my comments today. As originally filed, the MDS OGDP was subject to Rule 604B1 because it obtained a valid and effective informed consent from the RBU owner located within 2,000 feet of the working pad surface of the proposed oil and gas location. The original informed consent, using the ECMC's template, was submitted with the original filing of the application, and MDS also submitted an updated informed consent, again, using the state's template, for the Commission's review on September 23rd, 2024. MDS has now twice obtained the explicit written agreement to the proposed location from the RBU owners, which satisfies Rule 604B1. MDS undertook a detailed analysis and application of the statement of basis and purpose relating to the informed consent, as was read into the record by the Commission during the August 7th hearing. The informed consents submitted by MDS meet the intent of the commissioners at the time of the mission change rules because it utilized the ECMC's own form of informed consent when meeting and discussing this project in great detail with the residential building unit owners. To further satisfy the Commission and to support this OGDP application, MDS continued its deep dive into the ECMC operator guidance issued in April 2021 relating to informed consent. The operator guidance clearly provides that the operator must, quote, provide each building unit owner with a formal request for informed consent and all required information about the oil and gas development proposed near them. The exact nature of the information that should be provided will vary on a case-by-case basis, depending on the site-specific aspects of the proposed location, but in general should include an informed consent letter, the use of the informed consent template letter, which MDS utilized. Operator may use a letter of their own construction. This does not apply because MDS used the state's template. The letter must clearly demonstrate both that the recipient has been fully informed and has provided consent consistent with Colorado law, which MDS will show here in a minute on the letter. The letter must have a space dedicated to consent determination, including a space for signature and date, which MDS has complied with. And for consent to be considered informed, the information must be provided to the recipient in a language they understand, which occurred in this instance. The operator guidance also provides that the use of the state template is not required, but is strongly recommended, as they clearly inform the recipient of their rights and options in making an informed consent determination. Again, MDS used the ECMC informed consent template for both its original and its updated informed consent obtained from the building unit owners and satisfies the expectations of the ECMC operator guidance. As evidence of MDS's full compliance with Rule 604B1, MDS is meeting the intent of the rule, the statement of basis and purpose, and the ECMC director and staff's preferences in the April 2021 operator guidance. MDS has included the updated informed consent letter in this presentation. These slides illustrate that the ECMC informed consent template meets the required informed and consent components intended and preferred by the ECMC. This slide also illustrates that the ECMC informed consent template meets the required informed and consent components intended and preferred by the ECMC as well as the building unit owner's clearly defined signatures that they explicitly agree to the proposed location and the associated oil and gas operations, and they voluntarily provided informed consent. Based on slides 9 through 12 that I just showed you, it's clear that the MDS informed consent illustrates an explicit written agreement to the proposed surface or to the proposed location from every residential building unit owner and tenant within 2,000 feet of the proposed working pad surface. The informed consent also meets the recommended criteria set forth in the ECMC operator guidance and was prepared under the operator guidance's own language, allowing for a case-by-case and site-specific aspect of the proposed oil and gas location. To aid the Commission in understanding the MDS 8-59 oil and gas location a bit more, MDS took updated pictures on August 21st, 2024 of the residential building unit from the proposed location itself, which you can see in the top picture, as well as the seemingly vacant residential building unit in the bottom pictures. You can also see the very rural area or nature of this area. The original director's recommendation, issued on July 10th, 2024, provided a thorough analysis of the staff and director's review of the OGDP application and recommended conditional approval of the application. The conditional approval of the OGDP application is based on MDS's energy agreement to the two conditions of approval confirmed by Mr. Saudi during the August 7th hearing. They're listed on this slide for your review as a refresher. Additionally, on September 26th, the director issued an addendum to the July 10th director's recommendation for the OGDP application, which provided, and I quote, "On September 23rd, MDS emailed staff a revised informed consent letter, which has been attached to the Form 2A labeled Revised Informed Consent Letter, document number 1593056. Staff reviewed the revised informed consent letter and concluded that initial concerns regarding the original informed consent letter have been resolved. Staff considers this revised informed consent letter to meet criteria for consideration under Rule 604B1. No additional revisions will be made to the application prior to the Commission hearing scheduled for October 9th, 2024. The MDS Energy 8-59 OGDP application is an approvable application and is in compliance with ECMC rules. No petitions or public comments were filed. MDS holds an approved WOGLA permit and vested rights for the location. MDS has focused on consolidating operations to one well pad to prevent unnecessary surface disturbance. And the application and the location provides protections of public health, safety, welfare, environment, and wildlife resources. So we've reached the end of this fairly short presentation today, and we're grateful for your consideration of the application. Again, to conclude, MDS Energy is requesting that this commission approve the OGDP for the development of up to 7 wells within one 1,391.27 acre OGDP area, as well as the corresponding drilling and spacing unit. Provide that the 7 wells will be located on the MDS Energy 8-59 oil and gas location, unless the director grants an exception, and approve the associated Form 2A with the location. We ask that you find that the OGDP will protect and minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources, and will also protect against any adverse environmental impacts on any air, water, soil, or biological resource in compliance with Statute 3460-106-2.5A. At this time, I'd like to go ahead and ask the subject matter panel to join us on video for any commissioner questions that we may have, or you may have, not we. And then that concludes our presentation. Thank you.
Thank you, Ms. Jost. One quick question. On slide 12, that is the updated informed consent, it indicates that Luke Lindsay signed that document on October 22nd of 2024. Is that a mistake? It looks like the other fellow signed on September 22nd and it was uploaded on September 23rd.
Yes, Chair, and that would have been signed on September 22nd.
Okay.
Unless we have reached a portal, but
yeah,
yes.
Just checking for the record, noted
Yes,
that as
thank
we
you.
go through your things. Commissioners, the panel is open for questions. Commissioner Oath?
Thank you. And thank you, Ms. Jost, and to all of you. Appreciate all the additional work and information on the informed consent. I did have one question on a different part of the application. I just was noting that in CDPHE's consultation, they did note that we were unable to commit to using lower emission engines for both drilling and completion operations. So could you speak to that, given that I believe it's also in the ozone non-attainment area?
Yes, we can. Ms. Gross, is that something you would like to take? Or is that Mr. Jacobson?
It might be Mr. Jacobson. Let me look at my notes.
Great.
Unless Jim, are you ready to discuss that on an operational level?
On an operational level, I can talk about it, yes. So
Great. Go ahead, Mr. Jacobson.
the lower emission engines for drilling and completions are really dependent on what's available. And when MDS is prepared to begin well construction, then we would have to utilize what's available on the market for this project. Now, if a low emission rig and frac fleet are within reach, then yes, we would use them. But when there are not, then we'd have to use what's available. Now, I can say that virtually all of the rigs in Colorado are, they're compliant to some degree. So it would be a relatively, we'll use the best available that we can use for the well construction is my point.
I can also elaborate a little bit. MDS really would like to keep drilling and operations outside of the non-attainment zone months. And when discussing this, they were somewhat worried that if they were held to such a specific engine, then depending on availability, it may push them into operating in those non-attainment months. So I believe it is their intent, if available, they will absolutely use them. But depending on the availability and their scheduling, they would like the option to use what's available.
Yeah, Commissioner Oath.
Thank you. Appreciate that. So just a follow-up, Ms. Gross. Are you saying that how do I want to say this? It almost seems like you're saying, well, if we are to drill during the ozone season, there would be a commitment to using the lower emission drill engines, but don't want to commit just to the lower drill engines because if you want to drill out, because you may want to drill outside of the ozone season, and then you would not necessarily have access to the lower emission engines. So it could be a one or the other. Like, could there be a commitment to doing one or the other?
Potentially. I think what it is, it comes down to if they get an opportunity, the best opportunity to drill and complete outside of the non-attainment zone months, and the only available rig or engine would be those lower tiers, they want to be able to use those and stick to their drill schedule to stay out of the non-attainment zones. They do always aim for a tier 4 rig, but it's really due to the availability of the equipment. And they have a shorter contractual window than some of these larger companies. So they're sometimes they don't have the options as like some of the bigger companies that have come before you. So that they're kind of limited. They're more limited than other companies, if that makes sense. Does anybody from my PT want to elaborate? Or
so the number of Tier 4 engine powered rigs in the basin are in the single digits. There are a number of Tier 4 near equivalent dual fuel rigs in the basin that are available, and we have access to those when they come up. This area does not have the electrical infrastructure to support an electric rig, at least not currently. So that's where we're limited to keeping our options open and being able to be flexible with the lowest emission engines available at the time that fits our schedule.
Thank you, Mr. Jacobson, Ms. Gross. Commissioner Oath, is there, I guess I just want to make sure we have your question fully answered on that piece, because I understand the question and kind of where you're going with this. I think the concern that MDS would have with any full commitments as to what it can utilize in ozone season and outside of ozone season is really based upon kind of third-party rig availability. And as Andrea said, MDS doesn't have access to those as much as larger operators do, unfortunately, in this instance.
I appreciate that, Ms. Jost, and other commissioners will have more institutional knowledge of this than I do. I have kind of general awareness that operators of all sizes have been able to make these types of commitments. So I guess I'm not sure. I guess maybe you could speak to that a little bit more.
Yeah, Commissioner Oath, was that to me or to the other commissioners?
Sure, yeah.
Okay.
Yeah. No, sorry, yes, that was
okay.
you.
No, and I appreciate that. At this point, MDS, and again, please, anyone from MDS, correct me if I'm wrong here, but, MDS hasn't been able to get a commitment from the available rig contracts and rig companies to say, yes, you are guaranteed a Tier 4. And so while there may have been other operators in the state, maybe along the same size as MDS, to say we will utilize this, you also have to look at this on a case by case and kind of an operator specific basis as to the availability of rigs for those operators. So as both Mr. Jacobson and Ms. Gross said, MDS intends and will use Tier 4 if it is available. But they also are looking at this from the standpoint of also trying to potentially avoid ozone season development if they can. And so there is some form of balancing, I think, that has to come in there. The other piece of it is, in the rules, at least as of right now, there's no requirements for a specific type of drilling rig. And so we do have to look at that from the standpoint of where this OGDP is coming up kind of in time for purposes of the regulations that are in place.
Ms. Jost, sort of segueing on that, on slide 29 of the first slide deck had the operation phases and timeline, and it indicated that the construction and drilling were to take place in the fourth quarter of 2024. I think we're kind of in the fourth quarter of 2024. Does your client want to amplify that may have changed as a result of not getting an approval earlier? Because, we did continue this from August. And I guess I ask all that because it seems like if it's the fourth quarter of 2024, contracts for drilling rigs would have been accomplished by now. So I would love some clarification on that point.
Chair, thank you for that question. I'd like to ask Mr. Sade or Mr. Dunn or Mr. Jacobson to address the timing of operations.
Yeah, we still have the opportunity to construct this pad once the permits are approved. And no, we've not contracted the drilling rig yet until we have these permits approved.
So I'm sorry, that answer was not sufficient. You didn't say when.
Oh, I'm sorry.
Mr. Sade, do you
have to construct the pad? Well, of course you do if you get an approval. Are you still planning on constructing and drilling in the fourth quarter of 2024?
Oh, I think, yes, we could certainly construct the pad in the fourth quarter of 2024. I think probably not. We would probably not have the opportunity to drill the wells in the fourth quarter.
And Mr. Chair, if I may.
Yes, please.
Follow up. Thank you so much. Mr. Sade, when would you potentially anticipate drilling operations on this pad, even if you constructed the pad in the fourth quarter of 2024?
We'll revisit that as the team. We'll look at it together now that the hearing and the permit's been continued. I'll have to check with the team about our options there.
Okay, thank you. So, Mr. Chair, it looks like we'd have to get some information back on the drilling operations, but Mr. Sade, I think it's safe to assume that drilling operations likely won't occur in the fourth quarter of 2024. Likely that would carry over into 2025. Is that a fair assumption?
That's right. About drilling operations, that's correct.
All right, thank you. Commissioner Cross?
Thank you, Mr. Chair. And Mr. Sade, based on that, would the completion operations be pushed into the non-attainment season?
I'll have to consult with the team and look at the schedule on that again.
I can say that if there's only 7 wells to be drilled and completed on this pad, so depending if financially and operationally they could continue with a Q1 or Q2 drilling or completion, it would still stay out of the ozone months.
I think Q1, that definitely makes sense. Q2, I think even if it's 3.5 days per well, you're looking at about a month. If you're looking at Q2, you start to push into May or June or July there.
May or June, yeah, early May.
Okay, thank you.
Other questions for the panel? Commissioner Ackerman?
Yeah, thank you. We had some significant conversation during our first hearing about wildlife. The proposed location wasn't within wildlife high priority habitat at the time of application. It does fall within high priority habitat now with updated maps. With this schedule being pushed back into the areas that are probably the most concerning for CPW into the winter, has there been any updated conversation with CPW and any conversation about reconsidering some mitigative strategies associated with wildlife?
We haven't had any updated conversations with CPW. However, we're very open to them. I'll reiterate that in our original presentation, MDS was unable to commit to operating outside of the timing stipulations, which is, like you said, the winter months, in an effort to really prioritize not operating during the ozone season. However, we did discuss with CPW additional BMPs if operations do happen within those months, and we would be happy to have an updated conversation, even an on-site if CPW wanted that, if those operations were within that sensitive time frame, which it sounds like they may be. I believe that MDS would be happy to commit to updated conversations with CPW and discuss other BMPs.
Thank you. I appreciate that.
Other questions for the panel? All right, seeing no further questions, we move into deliberations phase. Does any commissioner desire to initiate deliberations? Commissioner Oath?
Thanks, Mr. Chair. And this is certainly not conclusory thoughts. It really is to note that I am interested in a conversation with my fellow commissioners about this question and kind of how you have grappled with this in the past and options that are or are not available in terms of kind of opportunity for engines in these types of situations. you know. Well, and I'll add on to that, and then sort of the, I guess, I don't know if tension's the right word, but sort of the challenges within balancing that with kind of the wildlife issues that Commissioner Ackerman that you brought up.
Commissioner Messner?
Thank you, Commissioner Oath. Appreciate you bringing up this subject and the tension and the conversations and I'll just give you my perspective. You know, I do appreciate that the operator did submit an updated informed consent so that this application can be reviewed under 604B1. You know, I do think that it would be challenging in this application under a 604B4 review, but the informed consent as updated, as indicated by staff, you know, I think was appropriate. There is a tension between operators who operate in Colorado, and I think the vast majority of operators in Colorado, you know, do strive and do make commitments to timing stipulations, to you know, developing options for best you know, best engines available, and those engines, you know, at a minimum, you know, often we see dual fuel being committed to or natural gas being committed to, you know, things like that. And operators are generally pretty open to working with CDPHE and developing those commitments. And, you know, I think the push and the pull and the challenge here is, you know, with conformed consent and under a 604B1 review, the current rules don't provide a lot of teeth to be able to require certain engines or certain drill rigs or certain operations. I think we still have to review every application to ensure it's protective of public health, safety, welfare, the environment, and wildlife resources. I think that we evaluate potential impacts to wildlife inside and outside of high priority habitats, because that's still, you know, one of our guiding principles. And I think the same is for protection of, you know, public health, welfare, and the environment. When even when there is a 604B1, you know, review process, we do have to still ensure that what's being proposed here is protective. You know, my take on it is that this operator is not willing to commit to any particular engine type or any particular timing stipulations. You know, and that well, not to project anything, but to me that actually you know, ties into, you know, why you're seeing additional legislation and requests for rule changes in order to address this in future applications. From my perspective in this application, with the updated 604 or updated informed consent and review under 604B1, you know, I do think it's a approvable application and would have a hard time tying a specific engine type in this particular situation to this application, but that's just my thoughts.
Commissioner Ackerman?
Thank you. And I'll supplement that from kind of the wildlife perspective side, as there often is this push and pull between trying to, and it's a difficult situation and requires a lot of careful planning to be able to work to avoid ozone season issues, as well as winter timing stipulation issues, particularly in high priority habitat. And as I stated, the application was submitted when the 2022 HPH map layers were in effect, which did not contain any high priority habitat, but it does now lie within two updated 2023 mapped high priority habitats. That's mule deer severe winter range and mule deer winter concentration area. And I'll just remind us that CPW did discuss those concerns with the operator at the time and suggested some mitigative efforts, and some of those were employed. But as Commissioner Messner stated, MDS didn't commit to any voluntary timing stipulations, which often operators will do, but as Commissioner Messner stated, the rules do not require them to do so. I think it's important to note that as per the APA, it requires that we consider applications under the rules as they exist at the time of application. And that's been my point of view from the perspective of the updating of the HPH map layers. I do think this adjustment in schedule, although unclear, as noted by the chair, it seems the construction and drilling is now going to take place throughout the winter timing stipulation period, which certainly will cause CPW concern and me additional concerns. Generally, the later you push into the winter timing stipulation periods, the more impact it has. Again, there are various factors associated with that, but that's a good general statement. And so I would just say 2 points. I think it's very important that we ensure that we continue to have a timely updating process of the HPH layers each year. And I appreciate Ms. Grost's point, and I would think it might be appropriate to ask for additional consultation with CPW in consideration of additional BMPs as a COA in addition to those in addition to those COAs that have already been requested by staff, and maybe sound walls might be one of the areas that they could focus on. And so I do think that we have a couple of difficult situations here, but also agree that as per our regulations and as per our review procedures from a wildlife perspective, this does fall within an approvable realm.
Thank you. I agree with both points made by the commissioners in terms of where this application lies as against our current rules, and do find it approvable, in particular under 64B1, and appreciate the additional information provided on that front. Commissioner Ackerman, I wonder, do you have some thoughts about language on the HPH and the additional wildlife consult, given the changes in potential timing, et cetera? I would agree that I think there is a need for some additional consult. I'm just not sure how to frame that out so that we end up with a protective approach, given that there's continues to be uncertainty from the applicant and as to when they're actually going to be doing their work.
Yes, thanks for asking, Mr. Chair. I think the best I can probably provide is a COA that requires additional consultation with CPW and implementation of additional BMPs associated with that consultation, with a focus on sound walls.
Thank you for that. Further deliberation from the board? Commissioner Ackerman and then Commissioner Cross.
Sorry, and an addended clause to that, the last statement, minimization of traffic to the extent possible as well.
Yep. Okay. Commissioner Cross.
Thank you, Mr. Chair, and thank you, Commissioner Ackerman. I guess I just wanted to ask one clarifying question with respect to the COA. So understand the additional consultation with CPW and then implementation of BMPs. Does that mean it would be a condition to impose those BMPs, or that's the kind of thing you intend for them to investigate as part of the consultation?
Yeah, thanks. The way that I proposed it is that it is a condition of implementation of BMPs associated with that consultation.
I guess while we have Ms. Joe stop, I guess I'd appreciate any thoughts if there's concerns with that from the operator side as well, or if that's something they'd be willing to agree to.
Ms. Jost?
Yes, thank you, Chair, and thank you for the opportunity, Commissioner Cross. So MDS will absolutely agree to consult with CPW prior to construction. I think the question would be is what newly committed BMPs would that be without having that consultation? And Commissioner Ackerman, I completely hear what you're saying with respect to examples for those BMPs. Would we be able to agree to a condition of approval that requires MDS to engage in the consultation prior to construction, and then basically reporting any additional BMPs that were requested by CDPHE on this permit as like an updated or just like a sundry notice or something along those lines, and Commissioner Ackerman, I just want to make sure that I can't speak for CPW, and CPW is not here, so we don't know what those would ultimately end up being. That's my only concern with this kind of unknown.
And you referenced CDPHE first and then CPW.
Oh, CPW. I meant CPW. Thank you, Chair.
Commissioner Ackerman.
Thank you. And I think that's a reasonable point, and certainly considered that as I was proposing. I do think that there are implementable BMPs that I think can be agreed upon between the operator and CPW that will not add significant additional cost or concern for the operator, but that will have additional improvements for wildlife. I'm specifically being vague because I don't want to specifically state you must agree to certain practices. But I do think there is a situation exists in which CPW and the operator can agree upon some additional BMPs that will be beneficial to wildlife.
Yeah, and Commissioner Ackerman, Chair, if I may.
Yes.
I appreciate that. And just as a reminder, we didn't pull up our original presentation that listed the 55 BMPs. But as part of those, even in consultation with CPW, there will be sound walls already on site, and then there is pipeline takeaway. So we've already kind of addressed certain aspects of that of the site. And so again, that's where my mind was going with respect to not having kind of mandated talking points to BMPs, but just the full scale agreement that we will consult with CPW to see what might still be of concern.
Thank you. And I think we are narrowing in, Mr. Chair, on what I think is an appropriate COA at this point. The point's well taken that, it's difficult for the operator to commit to future unknown BMPs. And I do understand. And I appreciate the clarification on the sound walls. I had actually, it's been a while since we talked about this, so I forgot about that. It seems that they're incomplete sound walls, but I can't remember for sure. You might be able to clarify on that point. Again, I do think it's important that you meet with CPW and talk about additional protective measures. I think certainly we can mandate that as a COA. I guess what I would say, Mr. Chair, is my expectation would be that there will be a good faith effort to implement any additional BMPs suggested by CPW as a result of that consultation.
That sounds good. Do you want to desire to cobble all that in together into a motion? Would you like me to call upon AAG Davenport for some help on that front? What are your thoughts?
I would love to hear from AAG Davenport on that front, reminding him that there are also 2 additional staff COAs.
Thank you. Commissioner Ackerman, would you restate what you'd like to see in the motion?
You bet. I think it would be appropriate from the COA that I'm talking about to require additional consultation with CPW and implementation and a good faith effort to implement any additional BMPs that result from that consultation.
Okay. Thank you. Sorry, my computer's being weird. There we go. Do you have a thought on a deadline for that consultation?
I do not. I think the nature of the desire to press forward on this project from the operator will implement that with some degree of exigency. So I don't know that it's necessary that we impose a deadline.
All right. Then I suggest a motion to approve the application that includes the COAs within the director's recommendation and also requires the applicant to consult with CPW. And I'm just going to suggest prior to beginning any construction at this location. And I should add as well that consultation with CPW will be in good faith and that the applicant will make efforts in good faith to implement any BMP suggested by CPW.
Okay, that sounds good. Do we have a commissioner that wants to make that motion? Commissioner Ackerman?
Yes, I'll make that motion. Thanks, Mr. Chair.
All right, we have a motion. Do we have a second?
Mr. Chair, I'll second.
Motion and a second. Further discussion on the motion.
Yeah, I'd like to just state one thing. I understand that this operator is new to the state of Colorado, and I think operators in the state of Colorado have a very proud tradition of setting a very high standard to how they operate in this state. And this application, while approvable, was certainly not best in class. And so I'm voting to approve this, but hope that there's an opportunity to see how other operators are operating in the state. And so I'll leave it at that.
Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Okay, motion carries. Thank you, Ms. Jost, to your team for the work, and thanks to our staff for helping us move through this. Took a couple of hearings, but I'm glad we got to the result that's appropriate.
Thank you, Chair. Thank you, Commissioners.
Let's take a little bit of a break and return at 10:21, and during that time, if we could load up the Verdad Resources panel on docket ending in 0112. All right, welcome back. We now have docket 240500122, an oil and gas development plan proposed by Verdad Resources. We have Joe Pershella as attorney for Verdad. The subject is the Verdad Hornet 0136 OGDP. This matter is located in Weld County, and we generally hear from Weld County at the outset of the docket. And so I see that Ms. Holliday is with us. Ms. Holliday, you're recognized if you would like to speak to this docket.
Thank you, Chair Robbins. Good morning, Commissioners. Thank you for the opportunity to speak with you for a few minutes today regarding Weld County's process for the Verdad Resources Hornet 0136 Oil and Gas Development Plan. On December 4th of 2023, Weld County held a pre-application meeting for the Hornet 0136 location before you today. Attendees included Verdad staff, Weld County staff, ECMC, CDPHE, CPW, and the BLM. The 1041 WOGLA application was received on May 10th of 2024. Weld County did not receive any public comments or applications for intervention on the Hornet location. The 1041 WOGLA hearing for the Hornet was held on August 22nd of 2024 and approved by Weld County's hearing officer. The final order was recorded with Weld County's clerk and recorder and published in the Greeley Tribune on September the 11th of 2024, which creates a vested property right for this permit. 2A comments were submitted to the ECMC and are included in the director's recommendation. Weld County agrees with the director's recommendation and supports the approval of this permit. Those are all the comments I have prepared for you today. I'd be happy to answer any questions.
Thank you very much, Ms. Holliday. Does anyone have questions of Ms. Holliday? All right. Commissioners, I'd like to potentially discuss an audible with you. We've got a busy day ahead of us, and my review of this docket is that it is fairly straightforward with not a lot of contentious issues. We have the opportunity, and we haven't done this very often, but just to sort of take the matter up on the pleadings, as opposed to, feeling a need for a full presentation from the applicant, et cetera. That's not to dismiss that the applicant does a great job with presentations. It's just that sometimes we can move things along. I'm comfortable in that regard, but I'm only one commissioner. And if any commissioner desires to hear the presentation and other things, we absolutely will do that. But I wanted to raise this as a matter of uniqueness and maybe potentially see where we might stand on that. With that thought, I look to my fellow commissioners for thoughts on process. Commissioner Ackerman?
Thanks, I agree and have no objection, Mr. Chair.
Anyone with any further concerns? All right, Mr. Priscilla, we've called an audible. We don't we don't need to hear from you. No, we do need to hear from you, but in a question and answer format only. Do you have any witnesses that are available if we have questions of witnesses on the application, or can we just ask you questions?
We do have witnesses available if there are technical questions that I can't answer. That's Heather Mitchell, Mike Cognetti, and Allison Schreiber, and they are elevated as panelists. So to the extent that I can't answer a question, I would defer to them.
All right. Well, let's go down the path of questions and for you. Do commissioners have questions on this application for either the attorney or the subject matter experts? All right. Seeing none, we move into the deliberation stage. I would move approval of the application as presented.
Second.
Motion and a second. Is there discussion on the application or on the motion? Commissioner Messner?
Thank you, Mr. Chair. I just want to make a statement that I appreciate the quality of the application and have read all of the materials in the application and the presentation as well. I will note that even though this has no sensitive receptors around it, it is proposing utilizing a drilling rig with AC electric powered, and it is powered by 2 natural gas generators backed up with battery power and a reserve dual fuel generator. So not necessarily tied to grid, but this is a great opportunity for unique solutions for areas that may be in the non-attainment area but don't have sensitive receptors around it. They were also looking at or utilizing a electrified hydraulic frac fleet that electricity generated on-site or off-site. If it's on-site, it's natural gas powered. And so this is a good example of kind of going above and beyond. And so I just want to indicate that I appreciate that.
Commissioner Oath?
I just want to echo those statements and say I think those are reasons why we are all comfortable, right, moving forward in kind of an expedited way this morning, and appreciate the application and for all of the reasons that Commissioner Messner noted. So thanks.
Yeah, no, I think both of those points are very appropriate, and I appreciate my fellow commissioners making them. I want the 84 participants that are listening in to understand that the fact that we've moved forward with a motion and it's likely to be approved is indicative of not that we've not reviewed it or not that the applicant did a not good job. It's exactly the opposite. This is a very provable application. We appreciate the time and effort of Verdad and you, Mr. Priscilla, as well as our staff for getting it to us, and we look forward to other applications such as this in the future. Any further discussion? Seeing none, all those in favor of the motion signify by saying aye.
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 Any opposed? Motion carries. Thank you, Mr. Priscilla.
Thank you very much, commissioners, and really appreciate the commentary and support for the application. Verdad really has worked hard on this, and we look forward to coming in front of you with further excellent applications. Thank you.
Thank you. All right. That went well. Moving to docket 2403-00074. This is an oil and gas development plan, Kearmagie Oil and Gas Onshore. It is called the Larkspur Fed OGDP. And noting that this is also within Weld County, we will open this matter up again with a presentation from Ms. Holliday.
Thank you, Chair. Good morning. We didn't get to afternoon yet, huh? Commissioners, and thank you for the opportunity again to speak for a couple of minutes about Weld County's process regarding Kearmagie's Larkspur Fed Oil and Gas Development Plan. Weld County held a pre-application meeting for the Larkspur Fed location on October the 4th of 2023. Attendees included Kearmagie staff, Weld County staff, CDPHE, and ECMC. The 1041 WOGLA application for the Larkspur was received on April the 2nd of 2024, and Weld County did not receive any public comments or applications for intervention on this location. The 1041 WOGLA hearing for the Larkspur was held on June 1st of 2024 and subsequently approved by the Weld County hearing officer. The final order has been recorded with Weld County's clerk and recorder and was noticed in the Greeley Tribune on June 26th of 2024. This approval creates a vested property right pursuant to Article 68 of Title 24 of the Colorado Revised Statute. The 2A comments were submitted to the ECMC and are included in the director's recommendation. And Weld County agrees with the director's recommendation for approval on this application. That's all I have prepared.
Thank you so much. We appreciate it. Any questions for Ms. Holliday? Again, we always appreciate Weld County's involvement with us. We appreciate the presentation of the relevant local government and the thoughts, and it helps us as we move through the criteria that we review, one of which is indeed the involvement and participation of the relevant local government. So thank you, Ms. Holliday, for being with us.
Thank you.
Great. And true to form, I see the attorney for the applicant, Ms. Wazelinski, showing up. Good morning. Do you have witnesses that we need to swear in?
We do, yes. It looks like we've got our panel coming into the hearing now. Unless I'm just not seeing them, it looks like we're missing Chris Honus, Joseph Reimer, and Corey Altenberg. So maybe while we get everyone on screen to swear in, I think we just need to admit those last three witnesses, and we've got our full panel.
All right. Mr. Davenport, if you'd like to go ahead and get started with the witness swearing ins, that would be great.
Thank you, Chair. Thank you, Ms. Wazelinski. Witnesses, I'm going to ask you in turn to raise your hand, say your name, and say that you swear to tell the truth. I'll call your names in the order that you appear on my screen. First, Mr. Wells.
Wells, and I swear to tell the truth.
Thank you. Mr. Schlickmeyer, I apologize for mispronunciations.
Chad Schlickmeyer, I swear to tell the truth.
Thank you. Ms. Lindblom.
Paige Lindblom, I swear to tell the truth.
Thank you. Ms. Eichenberger.
Julia Eichenberger, I swear to tell the truth.
Thank you. Mr. Seastrom.
Seastrom, I swear to tell the truth.
Mr. Loundigan.
Nick Loundigan, swear to tell the truth.
Ms. Hedda. Sorry, Ms. Hedda, you were on mute.
Apologies. Sherry Hebda, I swear to tell the truth.
Thank you, Mr. Nelson, excuse me.
Justin Nelson, I swear to tell the truth.
Thank you, Mr. Rader.
Anthony Rader, I swear to tell the truth.
Thank you, Ms. Cray.
Carissa Cry, I swear to tell the truth.
I apologize. Ms. Wazelinski, is that everyone?
I believe we're still missing Mr. Honus and Mr. Altenberg, but why don't we go ahead and start? And if we have questions for them after our presentation, we can swear them in at that time.
Thank you. Does that work for the commissioners and the chair?
Yeah, that's fine.
Thank you.
Great. We'll get our PowerPoint up and then I will get started. Okay, good morning, commissioners. My name's Kelsey Wazelinski with Jost Energy Law, and with Jamie Jost, we represent Kermit in the Larkspur Fed OGDP before you today in docket 2403-00074. I would like to thank Ms. Holliday for her comments today and Weld County for its participation through the WOGLA process and the county's support of this OGDP. And we'd also like to thank ECMC staff and the director for their efforts on this OGDP. Next slide. The Larkspur Fed OGDP proposes one new oil and gas location, the Larkspur Fed 4-32H Z-Pad, to develop 10 new horizontal wells within one new proposed drilling and spacing unit, totaling 1,281.16 acres for the Niobrara, Fort Hays, Codell, Carlisle, and Sharon Springs formations. There are federal minerals within the proposed DSU, and Kerr-McGee will submit a communitization agreement to the BLM prior to drilling operations for a well within the application lands. As Kerr-McGee will describe today, The federal APDs are in the process of review with anticipated approval in Q4 of 2024. The Larkspur Fed Pad is located in Weld County, and as Ms. Holliday mentioned, the WOGLA was approved in June of 2024. This OGDP triggers one Rule 304 ALA criteria for an intermittent and non-jurisdictional wetland. Kerr-McGee conducted an ALA, consulted with CPW, and CPW waived the 500-foot chemical storage requirement in Rule 1202A3. The location does not meet any other ALA criteria and specifically is not within 2,000 feet of any RBUs, high occupancy building units, schools, childcare facilities, nursing homes, hospitals, or designated outdoor activity areas. In addition, the location is not within any CPW mapped high priority habitats. The nearest RBU to the location is just over 2,000 feet from the working pad surface, and the proposed location is not within any disproportionately impacted community. As Kerr-McGee will describe in the presentation today, the nearby RBUs are abandoned, will not be occupied, and the owner of these abandoned residences has submitted a letter of support for the OGDP application. Kerr-McGee did consult with CDPHE as part of this OGDP due to the proximity of the abandoned RBUs, and will describe its consultation with both CDPHE and the RBU owner in the presentation today. As part of the Larkspur Fed OGDP, Kerr-McGee has committed to plugging and reclaiming 33 wells within 1 year of all new wells turning on to production and decommissioning 10 facilities. Kerr-McGee will describe the associated emissions reductions in the presentation today. And finally, Kerr-McGee has complied with all notice requirements for the Larkspur Fed OGDP. No formal petitions were filed and no public comments were received on the Form 2A. So with that, I will turn it over to Matthew Wells with Kerr-McGee to continue the presentation.
Yes, thank you, Ms. Wazelinski. Good morning, Chairman and members of the Commission. My name is Matt Wells, and I'm a regulatory advisor at Kerr-McGee Oil and Gas Onshore, a subsidiary of Oxy USA. Joining me are several subject matter experts to answer any of your questions if you have any. Here's an overview of the permitting timeline for this project. From the first pre-application meeting with Weld County, the ECMC, the CDPHE, and Colorado Parks and Wildlife in October of 23 to September when Kerr-McGee received the director's recommendation. Noteworthy here is there were no public comments and no petitions filed against this application. Here you see our estimated phases of operation timeline for the Larkspur Fed project, from pad construction starting in November of 2024 all the way to interim reclamation in March of 2026. Here's an up-close view of the proposed Larkspur Fed location. Kerr-McGee has an executed surface use agreement in place and has received an approved 1041 WOGLA from Weld County on June 28th of this year. 7 of these wells will require federal permits, and these APDs were submitted in June and are on track for a Q4 approval. Here we have a look at the proposed location and the proximity to receptors. As you can see, there are 0 residential building units, 0 high occupancy building units, no schools, no daycares, or designated outside activity areas within 2,000 feet of the working pad surface. The proposed location is not within high priority habitats nor floodplains. Burrowing owl surveys were completed in July and November of 2023, and no owls were identified. Kerr-McGee will perform burrowing owl surveys once again prior to the start of construction. There is an intermittent and non-jurisdictional wetland to the west of the proposed location associated with the Platte building pitch. The presence of this intermittent wetland triggers Rule 1202A3. Kerr-McGee has applied and received a CPW waiver for this rule for the Larkspur Fed location. Due to the proximity of this intermittent wetland, Kerr-McGee performed an alternative location analysis and reviewed 3 other potential locations. An alternate location in the southwest quarter of the northwest quarter of Section 29 was reviewed. This location has 1 RBU within 2,000 feet, and there are some subsurface concerns that we have, and for those reasons, this spot was not chosen. An alternate location in the southwest quarter of northeast quarter of Section 32 was considered. This location has 0 RBUs within 2,000 feet, but the surface owner preferred agricultural use for this location. And an alternative location in the northeast quarter of the southwest quarter of Section 5 was considered. This location also has 0 RBUs within 2,000 feet. This location is closer to the Platteville ditch and would be more challenging to reach all the minerals of the DSU versus our preferred location, and for those reasons was not selected. Kerr-McGee is proud to be able to commit to plugging 33 older wells and decommission 10 associated facilities with this OGDP application, effectively removing 9 produced water tanks and 11 oil tanks from this general area. Plugging these wells and removing these facilities will eliminate over 800 truck trips annually to those sites. We also anticipate that we will be able to reclaim approximately 14.3 acres, which means we will reclaim 8.5 more acres than the proposed Larkspur-fed site will ultimately disturb. And of note, 2.1 of those acres that we're reclaiming are currently in high priority habitat. I also want to highlight the table of estimated emissions avoided from these wells that we will be plugging. This information has been incorporated into our application in coordination with ECM staff and for this OGDP. The aerial map on this slide shows the haul route that has been designed to efficiently route traffic to the nearest paved arterial roads. This route has been approved by Weld County, and Kerr-McGee has also secured an access permit from Weld County Planning Department. Now let's talk a little bit about produced water takeaway. Kerr-McGee evaluates produced water management at a regional level, and produced water takeaway is vetted for every proposed location. Part of this scoping process is to evaluate if there are any viable third-party pipeline options we could tie into. Unfortunately for this project, there are none in the area. The nearest capable disposal facility is 5.2 miles to the southwest. However, the pipeline route to this SWD would be considerably challenging and would have numerous acres disturbed in high priority habitat, floodplains, and wetlands that are all associated with the South Platte River. This route would also go through a DIC. So this option is not a great one. But Kerr-McGee did not stop there in our pipeline evaluation process and did further scoping of other possible pipelines to saltwater disposals to the east. The next nearest saltwater disposal, 7.2 miles to the northeast. As you can see on this map, the pipeline path would have an estimated 43 acres of disturbance and impact 9 RBUs. We must also take into account our produced water recycling goals. The produced water that will come from the Larkspur fed, once they're turned on, will most likely be recycled and used for completions at a future Kerr-McGee location that is looking like to be opposite in the direction of that SWD. So if we did pipe water to that SWD, we would just then have to turn around and truck it from there to the recycling operations, which would in turn just be a longer drive than trucking it straight from the Larkspur fed location. So with these considerations, it was determined that building this pipeline would result in an overall greater impact to both the environment and the community versus trucking the produced water. In respects to emissions, there are 2 things I want to highlight on this slide. The graph shows the reported CO2e intensities for Kerr-McGee's new facilities that have been commenced operations after December 31, 2022. The orange, blue, and green lines show the Regulation 7 new facility intensity requirements from the years 2023 to 2030. As you can see on the x-axis, the blue bars represent 7 Kerr-McGee facilities that have been commissioned after December 31st of 2022, and their respective levels of CO2 intensity, which are all significantly below the thresholds that have been set by the CDPHE. So these state-of-the-art design facilities, coupled with the best-in-class BMPs, has resulted in the lowest emission inventory of any oil and gas operator in the state and helped us meet the 2030 Reg 7 targets. The other thing I want to highlight is the drilling rig power commitment. Kerr-McGee always explores the option for electric rigs for each of our OGDPs, and Larkspur Fed was no different. If the grid availability and the drilling rig availability and other factors all align, that will be the case. But at a bare minimum, Kerr-McGee commits to adhere to the AQCC use practice rules as outlined in Regulation 7, Part B, 6E1, and We will practice these ozone season practices all year round, not just during the May to September ozone period. Kerr-McGee had the opportunity to consult with the CDPHE on the proposed Larkspur Fed location at the pre-application meeting in October, but also again at an official consultation on July 31st of 2024. Kerr-McGee commits to 31 of the CDPHE best management practices. I always like to highlight this graph as it shows the excellent work that the Kerr-McGee operations teams are doing to adjust, reschedule, or avoid certain activities during the ozone season to mitigate emissions. Here you see just a few of our best management practices that we will be implemented to minimize operational impacts to receptors as much as possible. They include inspections, temporary emission control devices, drilling rig with sound reduction features, and a quiet completions fleet. The grading and drainage plans were all approved by the Weld County Planning Department and submitted as a part of this application. Over the past 4 years, using the approved air monitoring program, Kerr-McGee has collected over 11,000 air samples spanning all phases of oil and gas development. And all results, as shown on that graph on the left, are well below the CDPHE's health guidance value of 9 parts per billion for benzene. The air monitoring plan for this OGDP has been approved by the CDPHE on August 6th of 2024. The map on the right shows how Kerr-McGee will position the air monitor sensors around the Larkspur Fed location. The air monitoring summaries for this location will be posted to the Oxy stakeholder website monthly. These next two slides showcase Kerr-McGee's stakeholder relation outreach efforts. I would like to highlight that Kerr-McGee did receive a letter of support from Mr. Herman, who is the surface owner of the 2 RBUs closest to the Larkspur Fed location. In his letter, he confirms that those 2 structures are abandoned and there are no plans to have them occupied. In this picture, you can see that we have placed a large sign on Weld County Road 26 near the proposed site, indicating that a proposed oil and gas location is in the works. We provide our stakeholder relations phone number there for anyone to call with questions or concerns. And to this date, we have not received any calls regarding the Larkspur Fed location. You couple that with the numerous phone calls and emails, mailed out material, and in-person meeting that our stakeholder relations team has done, and we feel very strongly about our community outreach efforts for this project. The timeline of those engagements. These communications have been taking place now for over 10 months and will continue to take place as we move forward with this project. Before I turn it back over to Ms. Wazzalinki, I'd like to summarize a couple points. No petitions were filed against this OGDP, and no public comment against this application was received. Cumulative impacts will be minimized by plugging 33 older wells, removing 10 facilities, and reclaiming approximately 14.3 acres, with, again, 2.1 of those acres in high priority habitat. Kerr-McGee is proud to present the Larkspur Fed OGDP and is confident in our ability to develop this location in a manner that protects public health, safety, welfare, and the environment and wildlife resources. Thank you for your time. Ms. Wazzalinki, I'll hand it back over to you to conclude this presentation.
Thank you, Mr. Wells. This slide shows the relief requested for the Larkspur Fed OGDP, and this does conclude our presentation today. So we can go ahead and take the PowerPoint down and have our team of subject matter experts turn their videos on for any questions you may have.
All right, great. I see the panel is before us. Commissioners, questions for the panel on the presentation? Commissioner Messner?
Thank you. Just a quick question, because I'm not as familiar with CDPHE regulations as ECMC regulations. So I can't remember in the Reg 7 regulations that were cited regarding drill rigs. What are those allowances in there for drill rigs so that I have a better idea?
Yes, thank you for the question, Commissioner. And I'd like to highlight our air quality manager, Carissa Cry, to go more in depth into the Regulation 7 ruling.
Yeah, I can answer that. I'm Carissa Cry. I'm an air manager. CDPHE has a list of choices during ozone season for both drilling and completions that can be used to meet that 30% governor's NOx reduction. So it has options such as natural gas usage, Tier 4, or dual fuel or electrification.
Okay, that's helpful. So that's the only question I have. Thank you.
Okay, great. And as we are waiting for additional questions to the panel, I would ask the CDPHE liaison, Tessa Sorensen, to potentially visualize, because she may also be able to provide us with perspective to the question asked by Commissioner Messner, and she is one of our SMEs. So while we wait for Ms. Sorensen to show up, other questions for the panel?
Mr. Chair, Ms. Sorensen has been elevated.
Great, thanks. There's so many people. I've got to scroll through like 3 different places to find folks. Good morning. Did you want to weigh in on the question from Commissioner Messner as well as the answer from the applicant?
Certainly. Thank you, Mr. Chair. So the question was, just to summarize, to make sure I understood the question from the commissioners, that what is allowed in terms of engine choices by Regulation 7 for APCD and AQCC. The answer is a combination of things. It's very, very agnostic technologically on purpose. There are two different classifications. There are locations that are within an AQCC defined cumulatively impacted community, which this particular application is not. And there is also everywhere else. In terms of everywhere else on that, the answer is many things, including Tier 4, which could be a Tier 4 with dual fuel. It could also be in calendar years 2024 and 2025, Tier 2 dual fuel engines are allowed. There is also Tier 2 diesel engines combined with operational practices that guarantee lower emissions. There are ways to set up Tier 2 diesel engines so that they emit the same amount as a Tier 4. They are not necessarily common, but they are absolutely well known. And I do know some operators do employ those. We also allow natural gas engines, or really there's kind of an off-ramp there that is, we say, and I'm quoting here, other technologies or operational optimization methods as approved by the division, which basically is something that is equivalent in the judgment of the division, as evidenced by whatever's presented by the operators. So yes, there are many ways there. Did that answer your question, commissioners?
I think it did, but it was Commissioner Messner's question. Do you have anything further on that point?
Do I?
Yeah.
No, I don't know always what's in Reg 7, and so when they put Reg 7 in a as a BMP or in a presentation, I need to understand what's in Reg 7. So oftentimes not, or to hear exactly what's in it. So
thank you very much for the answers to the question. Are there
no problem? Thank you, Mr. Chair. FYI, those in Reg 7, they are referred to as use practices in there. So just to be the specific language for each one.
Great. Thank you so much. Appreciate you being with us. Other questions for the panel? All right. Seeing none, we move into deliberations. Does any commissioner desire to initiate deliberations on this proposal? Commissioner Messner?
Yeah. So I'll move approval of the application at the end. I just want to indicate that I do appreciate the quality of the application and the work that's done on the application. I think that there's some things that are highlights for me, which is the plugging of 33 wells, the retirement of 10 facilities, and the associated tanks with those. 8.56 acres reclaimed more than impacted, with 2.1 acres of those in high priority habitat. So I think these are good things. And I think that this operator in particular, while I think given the flexibility of utilizing all the tools that are available in the Reg 7, as Ms. Sorensen indicated, for drilling rigs, does strive to really look at the absolute best that they can access at the time. And I think that's been evidenced by stepping up more than that they committed to in previous applications at the time of drilling. And so I would move approval of this application.
Thank you for the comments and for leading off. Appreciate it, Commissioner Messner. Commissioner Cross?
Thank you, Mr. Chair, and thank you for leading off, Commissioner Messner. I agree. I will second the motion. I think, as always, it was very thorough. I appreciate the hard work put into this, especially the stakeholder outreach that's done by Oxy in these situations. So I will second.
Motion and a second. Is there further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Wazelinski. Appreciate the presentation and for being with us. Let's try to see if we can get one more before our morning break. 2401-00016, Crestone Peak Resources, the Aspen North and South OGDP. Ms. Jost.
Yes, thank you, Chair. We do have a few panelists that we'll need to bring on screen. Like they are coming in. All right, it looks like we need two more. That would be Casey Decker and Emily Swanson.
As we're waiting on the last, Mr. Davenport, do you want to go ahead and get started with the swearing in of the witnesses?
Thank you, Chair. I'm going to ask each one of the witnesses to raise their hand, state their name, and say that they swear to tell the truth. I'll call your name out in order that you appear on my screen. We'll start with, and I apologize for mispronunciations in advance, we'll start with Mr. Annable.
My name is Jeff Annable. I swear to tell the truth.
Thank you, Mr. Harrington.
Name is Dan Harrington. I swear to tell the truth.
Thank you, Mr. Farkas. You're on mute, sir.
My name is Scott Farkas. I swear to tell the truth.
Thank you. Miss Ehlers.
My name is Natalie Ehlers, and I swear to tell the truth.
Thank you. Am I missing anyone, Miss Jost?
We do have Miss Emily Swanson on.
Oh, thank you. Miss Swanson.
My name is Emily Swanson. I swear to tell the truth.
Thank you.
And Mr. Davenport, we will not have Mr. Casey Decker, so we are good to go.
All right, great. Thanks.
Okay, the panel is the Zoom panel is yours, Ms. Jost.
Great, thank you, Chair. Let me go ahead and share my screen. Chair, are you seeing that okay?
Yes.
Wonderful, thank you so much. Well, again, good morning, commissioners, staff, council, and members of the public. My name is Jamie Jost from Jost Energy Law, and I, along with my partner, Kelsey Wazelinski, represent Crestone Peak Resources Operating, LLC, in the Aspen North-South OGDP application that was filed on January 12, 2024, and is before you today in docket number 2401-00016. Crestone would like to thank the City of Aurora for its participation through the local permitting process and its approval of the two oil and gas locations subject to this OGDP. And we'd also like to thank ECMC staff and the director for their efforts on this OGDP, as well as the box elder cap under which this OGDP was filed. As a refresher, The box elder cap was approved by this commission in order number 535-1396 on October 2nd, 2022. The order established an approximate 37,520 acre comprehensive area plan in the application lands for the development of oil, gas, and associated hydrocarbons from the Niobrara, Codell, Greenhorn, and J Sand formations. The cap provided Crestone with the exclusive right to develop within the box elder cap boundaries, a 6-year time period for the cap and OGDPs approved within the cap boundaries, and also mandated expedited review of the OGDPs within the box elder cap boundaries, among other things. The Aspen North and Aspen South oil and gas locations are in the northernmost area of the box elder cap and are within the city of Aurora. At the cap hearing, Crestone did seek, and the commission granted, preliminary siting approval for both the Aspen North pad and the Aspen South pad. In terms of the OGDP submittal, Crestone complied with all notice requirements for the OGDP. No formal petitions were filed, and a supportive public comment was submitted on behalf of the OGDP application. With that, I'd like to turn it over to Mr. Dan Harrington of Crestone to present the rest of the OGDP application to the commission.
Thank you, Ms. Jost, and thank you to commissioners and staff for having us here today to present this. I'd like to discuss here our planned Aspen North-South OGDP. This is a dual pad OGDP consisting of the Aspen 365 1514 North location. That location has already been built with 1 well. We're amending that to add 7 new wells. We also are adding the Aspen 365 1514 South location, which is a new location with 8 new wells. To further consolidate operations, the oil and gas facility will be located in Aspen South with tieback post separator from Aspen North. These 2 pads are aligned to approved sightings and well counts in the Aurora operator agreement, as well as the PSA sightings approved in the box elder cap. We have no RBUs, schools, child care centers, HOBUs, or DOA within a mile. These pads are in DIC, but there are no homes nearby. No ALA was required. A CDPHE consultation took place over the summer, and CPW declined to have a consultation. Next slide, please. Here are our planned wells. This is a single large DSU. We have 7 of those wells being drilled from Aspen North, 8 from Aspen South. These are 3-mile wells eastbound and 4-mile wells westbound, and you can see the existing 2-mile Aspen North well in orange. Next slide, please. There are a number of legacy wells in the area. The Aspen North well will continue to produce. We have a legacy horizontal also in the unit that was PA'd in 2023. And we have a number of legacy vertical wells that may or may not need to be remediated in the area. 2 of them on the south side will be. 1 has been done, 1 is on the schedule, and the northern wells are pending evaluation in the OWE that will go along with it. Next slide, please. Here's our development timeline. Aspen South, we will start constructing here in the 4th quarter and drilling likely only for surface holes in the 4th quarter with drilling and completions in 2025. And Aspen North sits about a year behind that, starting in late 2025, online by mid-2026. Slide, please. No ALA criteria were triggered for these pads. As stated, there's no RBUs within 2,000 feet. No working pad surface within 2,000 feet of an RBU in DI community, obviously. CDPHE has reviewed our BMPs and found that we remain protective of public health, air, and water resources. Next slide, please. As stated, these pads are both located within the city of Aurora and are aligned with the Aurora Operator Agreement pad sightings. The Aspen South permit is currently in progress at the city, and Aspen North will follow. Next slide, please. In terms of community outreach, we will be conducting a neighborhood meeting in conjunction with the COA process. However, our distances here are great. The closest RBU is 1.5 miles, and the closest neighborhood is 2.25 miles. So we're pretty remote at these locations. Next slide, please. Here we'll run through some BMPs. Electrification, we paid for an upgrade for electrical infrastructure to support an electrified production facility at Aspen South, as well as separators at Aspen North. We are on track to have those in place prior to first production. Produced water will be trucked. The nearest disposal well is in Weld County, up to 22 miles away, and the installation of that produced water pipeline would result in more service impacts than what would be generated by produced water traffic. Mainly in the first year. Next slide, please. Here we have our construction BMPs. We will utilize dust suppression, do avian surveys, and construct topsoil stockpiles properly. Next slide, please. For drilling, we commit to using a Tier 4 equivalent, or if available, a Tier 4 powered rig for the drilling phase, Group 3 mud, liners, and sound walls. Next slide, please. For completions, water will be delivered to the site with lay flat water line to reduce traffic. We will utilize Tier 4 equivalent or better engines during completions, as well as sealed containers for sand, polyethylene liners for spill control. We will flow back through the emissions controlled production facility, and will maintain the sound walls during the completion phase. Next slide, please. On the production side, the production facilities will be powered with utility power. As stated before, permanent production facility will be located on the Aspen South pad with the tie to the pipelines. Aspen North pad will only be wellheads, separators, and minimal additional equipment with tie back to Aspen South. Notably, all tanks will be located only on Aspen South. Oil and gas pipelines will be in place prior to first production. Tanks will utilize blowers. Pressurized maintenance vessel will be utilized. And you can see estimates of our produced water traffic here, up to 28 truck trips per day in the first year, reducing dramatically by year 2. Next slide, please. We did receive a director's recommendation for approval with 2 conditions around the waste management plan and the emergency response plan. Preston is comfortable with the language and confident we can fulfill these COAs. Next slide, please. Lastly, we ask for your approval of this 4,475 acre Aspen North South OGDP for up to 15 new horizontal wells, developing 1 new oil and gas location and 1 expanded oil and gas location. And hope that you will find that the Aspen North South OGDP will protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Thank you for your time here today. I'll turn it back to Ms. Jost.
Great. Thank you so much, Mr. Harrington. Commissioners, thank you for the consideration of this application. And I would just like our subject matter panel expert to go ahead and come on video for any commissioner questions that you all may have. Thank you.
Thank you for the presentation. We appreciate it. Commissioners, the panel is open for questions. Do we want to move to deliberations? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you for the presentation and for the thorough materials that were submitted and for the good work. This was a good application, and thank you for your summary here today. I appreciate the use of an existing pad and a number of other good practices, good coordination with the city of Aurora, the piping of fresh water, 3-phase takeaway, Group 3 mud, and either Tier 4 or natural gas with battery backup engines, just to name a few. Want to continue to encourage the reuse of existing pads where possible, and the good work that's done here. I move for approval.
We have a motion. Do we have a second?
Second.
Motion and a second. Is there further discussion on the motion? Well, seeing none, all those in favor of the motion signify by saying aye. 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 And any opposed? Motion carries. To the applicant, as was with the last applicant, we appreciate the really strong work here, the dedication to doing it right, and all of the the best management practices, et cetera. This is really helpful to us as we work through these matters, and so really thank you for the work, and want to thank behind the scenes the staff for their review to getting this to a space where it is approvable with little, if any, questions. So thank you all.
Great. Thank you, Chair. Thank you, Commissioners.
Commissioners, at least one of us has an obligation over the lunch hour that starts at 11:30. So if we could break now and come back, I think we could be able to come back by about 12:45. And then we will take up the rest of the agenda for the afternoon. All right, welcome back. Is it just me, or is the new Zoom lady scare us quite a bit with her? This meeting is being recorded. I got to get used to that. All right, all levity aside, we are now continuing with the Energy and Carbon Management Commission business meeting. It is 12:45, and we will take up docket 231200366, an oil and gas development plan for Noble Energy entitled the East Pony OGDP. And this location is also within Weld County. And so we first will recognize Ms. Holliday again. Nice to see you again. Thanks for staying with us.
Thanks, Commissioner. Thank you again for the opportunity to speak with you regarding the Weld County process, Noble Energy's East Pony OGDP. On September the 6th of 2023, Weld County held a pre-application meeting for the LG 09-03 and LG 09-20 locations, together making up the East Pony OGDP, which is before you today. Attendees at this meeting included Noble staff, Weld County staff, and the ECMC staff. Although CPW was unable to attend the meeting, they did provide comments in advance of the meeting, which were made part of the meeting record. These two 1041 WOGLA applications were received on February the 13th of 2024, and Weld County did not receive any public comments or applications for intervention regarding either of these applications. The 1041 WOGLA hearing for both the LG 09-03 pad and the LG 09-20 pad was held on April the 25th of 2024, and both locations were approved by Weld County's hearing officer. The final orders were recorded with the Weld County Clerk and Recorder and published in the Greeley Tribune on May the 10th of 2024. Creating a vested property right pursuant to Article 68 of Title 24 of the Colorado Revised Statute. 2A comments for both of these sites were submitted to the ECMC and are included in your director's recommendation. The Weld County Office of Oil and Gas Energy agrees with the director's recommendation and supports approval of Noble Energy's East Pony OGDP. And these are all the comments I have prepared for you today. I'd be happy to answer any questions.
Thank you, Ms. Holliday. Are there questions? All right, seeing none, we appreciate again Weld County's participation with us in our process. With that, we would turn to Ms. Wazelinski and her witnesses.
Thank you, Chair. We do have our witnesses here on the hearing. If we could all just be on video, they are ready to be sworn in.
AG Davenport.
All right, thank you. I'll get started as people are appearing. I'll ask all of the witnesses to unmute, raise their hand, state their name, and that they swear to tell the truth. I'll call your names out in the order you appear on my screen. First, Mr. Douglas.
Brant Douglas, land representative with Chevron. I swear to tell the truth.
Thank you, Mr. Ball.
I'm Tony Ball, Hall, land representative at Chevron. I swear to tell the truth.
Thank you. Mr. Rouse.
Jim Rouse, project management engineer with Chevron. I swear to tell the truth.
Thank you. Mr. Manning.
Marcus Manning, I swear to tell the truth.
Thank you. Mr. Keller. Sir, I can't hear you. I don't know if
No.
it's just me. Okay. Why don't we go to the next witness and we'll come back to you, Mr. Keller. Ms. Falang, apologies if I mispronounced that.
Tracy Fallingham, I swear to tell the truth.
Thank you.
Any luck, Mr. Keller?
Chair, while we're waiting for Mr. Keller, I still can't hear you. It looks like Miss Manerick has dropped off our panel, so she'll rejoin. She's not a presenter, but may be available for questions. So we'll hope that she can rejoin. And if she is asked a question, we can swear her in at that time.
Yeah, so we'll go ahead with the presentation and we will re-swear in the last two witnesses if and when that becomes necessary.
Wonderful. So I think with that, let's get our PowerPoint pulled up. Get that in slideshow mode, and then I'll get started. There we go. That'll work. Well, good afternoon, commissioners. My name's Kelsey Wasylinki with Jost Energy Law. And with Jamie Jost, we represent Noble Energy in the East Pony OGDP before you today in docket 2312-00366. I would like to thank Ms. Holliday for her comments today and Weld County for its participation through the WOGLA process and their support of this OGDP. And we would also like to thank ECMC staff and the director for their efforts on this OGDP. Next slide. The East Pony OGDP proposes 2 oil and gas locations, the new LG 0920 pad for the development of 8 new wells within an approximate 1,280-acre drilling and spacing unit labeled the DP220 DSU, and the expanded LG 0903 pad for the development of 8 new wells within an approximate 1,300-acre drilling and spacing unit labeled the DP221 DSU, for the development of the Niobrara, Fort Hays, Codell, and Carlisle formations. There are federal minerals within the proposed mineral development area, and Noble will submit a communitization agreement to the BLM prior to drilling operations for a well within the application lands. As Noble will describe today, the federal APDs are in the process of review with anticipated approval in the next few weeks. The new LG 09-20 pad and the expanded LG 09-03 pad are located in Weld County, and as Ms. Holliday mentioned, the WOGLAs were approved in April of 2024. This OGDP triggers no Rule 304 ALA criteria, and specifically the locations are not within 2,000 feet of any RBUs, high occupancy building units, schools, childcare facilities, nursing homes, hospitals, or designated outdoor activity areas. In addition, the locations are not within any CPW mapped high priority habitat. The closest RBU to either location is just over 5,000 feet from the working pad surface, and neither location is within a disproportionately impacted community. As Noble will describe in the presentation, the East Pony OGDP consolidates existing disturbance areas by utilizing the existing LG 0903 location, as well as an existing electrified production facility. All oil, gas, and produced water will be piped to the existing LG 04-15 multi-facility. In addition to citing new disturbance outside of sensitive receptors, Noble commits to utilizing electricity as much as possible to power the drilling rig, and when not on grid power, Noble commits to a Tier 2 natural gas or dual fuel drilling rig. Noble will describe its BMPs and commitments to avoid, minimize, and mitigate potential adverse impacts in the presentation today. And finally, Noble has complied with all notice requirements for the East Pony OGDP. No formal petitions were filed, and no public comments were received on the Form 2As. So with that, I'll turn it over to Tony Ball with Noble to continue the presentation.
Thank you, Kelsey. And good afternoon, commissioners. My name is Tony Ball. I'm a land representative for Chevron. I'll spend the next few slides describing each location in our development plans for the East Pony OGDP. I'll start with a brief overview of the mineral development for the OGDP. The OGDP proposes 2 new drilling and spacing units, the DP220 DSU and the DP221 DSU, both for 8 new wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. There are federal minerals in the DSUs, and Noble will submit a communitization agreement to the BLM at least 30 days before the anticipated date of first production from the initial well drilled within each of the DSUs. We submitted the federal APDs in April of 2024, and the public comment periods have been completed. We expect approval within the next couple of weeks. Next slide. I'm trying to get my webcam going here. The new LG 09 location is sited on rangeland, and we have an executed surface use agreement with the landowner. The 1041 WOGLA was approved by Weld County on April 25th of 2024. This location proposes 15.2 acres of surface disturbance during drilling and completion operations, reclaimed down to 5.6 acres of permanent disturbance. The location does not trigger any ALA criteria and is not within a DIC. Specifically, the location is more than 5,000 feet from the nearest RBU and over 1 mile from all schools, child care centers, public and surface water supply areas, and DICs. The location will have no impacts to floodplains or wetlands, and there will be no disturbance in HPH. As shown on the map, the nearest aquatic feature to the location are seasonally flooded emergent persistent palustrine wetlands located approximately 622 feet southwest of the location. The aquatic resources inventory reports for these locations confirm that there are no wetlands or non-wetland water bodies within 500 feet. As we describe more fully later in the presentation, all production from the location will be piped to the existing LG 04-15 multi-pad, location ID 457009. The LG 09-20 pad and the LG 09-03 pad were extensively evaluated for consolidation. After analysis, the terrain and an emergent wetland restricted expansion of the LG 0903 pad to the south, west, and east. An expansion north was restricted by the property line and existing flow lines, thus requiring the need for the LG 09-20 pad. Next slide. The map on the top of this slide shows the proposed working pad surface for the new LG 09-20 location and the 500-foot buffer in orange, the 1,000-foot buffer in green, 2,000-foot buffer in blue. Measured from the working pad surface, the location is over 1 mile from the most sensitive receptors. The closest RBU is 5,030 feet from working pad surface, and the DIC boundary is over 1 mile away. The map on the bottom of the slide shows a 1 mile buffer around the proposed LG 09-20 pad working pad surface and the location of the nearest high priority habitat. The mule deer severe winter range is located approximately 5,240 feet southeast of the proposed working pad surface, and we do not expect any adverse impacts to wildlife as a result of the East Pony OGDP. Next slide. Moving on to the amended, expanded LG 09-03 location, this pad is currently approved for 4 wells, and these 4 wells are producing on the existing location. Noble proposes to amend and expand the existing location to add 8 new horizontal wells. The location is also sited on rangeland. You have executed service with the landowner for the existing disturbance area and the proposed expanded disturbance area. The 1041 WOGLA was approved by Weld County on April 25th, 2024, and the location proposes 17.7 acres of surface disturbance during drilling and completion operations, reclaimed down to 5.7 acres of permanent disturbance. This location also does not trigger ALA and is not within a DIC. The location is over 1 mile from the nearest RBU, all high occupancy building units, schools, child care centers, public and surface water supply areas. The location will have no impacts to floodplains or wetlands. There'll be no disturbance in HPH. The nearest aquatic feature is temporarily flooded emergent persistent palustrine wetlands approximately 893 feet southwest of the working pad surface for the expanded location. The aquatic resources inventory reports for these locations confirm there are no wetlands or non-wetland water bodies within 500 feet. And as with the LGO 9-20 location, all production from this location will be piped to the existing multi-pad. To reiterate, the terrain and emergent wetland restricted our expansion of this location to the southwest and east, and expansion to the north was restricted by the property line and existing flow lines, thus requiring the need for 2 pad locations. Next slide. The map on top shows the proposed working pad surface for the LGO 903 location with our 500, 1,000, and 2,000 foot buffers. Measured from the working pad surface, the location is over 1 mile from all sensitive receptors, including RBU and DIC boundaries. The map on the bottom shows a 1 mile buffer from the proposed working pad surface and the location of the nearest high priority habitat. The mule deer severe winter range on this location is located over 1 mile southeast of the proposed working pad surface, and we do not expect any adverse impacts to wildlife on this pad as well. Next slide. As I mentioned, all production from the East Pony OGDP will be processed at the existing multi-facility located to the east and northeast of both locations shown on the map. In the planning stages of the East Pony OGDP, we took the opportunity to consolidate operations to reduce our overall surface impact of the development. Noble determined that the production facility that was originally planned for the OGDP was no longer needed, and production could be processed at the existing permitted LG 04-15 multi. As a result of this consolidation, the disturbance required for this OGDP has been reduced by approximately 8 acres since there's no need for a new facility. Our existing facility will not be expanded to accommodate the new production, and no equipment will be added. As my colleague will describe next, we plan to convert the existing tanked facility to a tankless, more modern design that will reduce production emissions. In addition, this facility will be upgraded and fully electrified. With that, I will now turn my presentation over to Tracy Falang.
Thank you, Tony, and thank you, commissioners, for your time. My name is Tracy Falling, and I'm a regulatory specialist for Chevron. I would like to walk you through the timeline for the OGDP East Pony project. Noble's planning for East Pony began in February 2023. In September 2023, Noble had a pre-application meeting with Weld County, and in December 2023, the OGDP was submitted. Moving into 2024, Noble submitted the Weld County WOGLAs in February and received the subsequent Weld County approvals in May. The federal APDs were submitted to the BLM in April of 2024, and approvals are expected in the near future. In August, Noble received OGDP completeness, and no public comments were submitted on this OGDP. In September, the director's recommendation was issued in preparation for this hearing. Next slide. As both East Pony pads are outside of HPH, construction is currently scheduled to begin in the fourth quarter of 2024, with drilling commencing in the first quarter of 2025. Completion operations would begin in the first quarter of 2026, with interim reclamation occurring in the fourth quarter of 2026. Next slide. These next few slides cover Noble's commitment to avoiding and minimizing environmental impacts associated with this OGDP. I won't discuss each BMP on the slides, but will highlight a few. For potential impacts associated with odor and air quality, Noble has procured power to electrify the facility, and our preference is to utilize electricity to power the drill rig whenever feasible. If grid power isn't available, Noble will switch to Tier 2 natural gas or dual fuel to ensure cleaner operations, with generators as backup for the facility. Utilization of the existing LGO 415 multi-facility is a vital component to enable us to avoid and minimize impacts. Noble intends on upgrading and converting the existing production facility to a tankless design to reduce emissions, and has implemented an advanced flowback design to further minimize the environmental footprint. All locations will include a continuous air monitoring program that is in accordance with the approved air quality monitoring plan for CDPHE. The images on the right show an example of view sensor data collected by the continuous air monitor. Finally, through the use of pipelines for oil, gas, and water takeaway, Noble not only reduces emissions, but also decreases the risk of accidents and road damage. Next slide. To avoid and minimize impacts related to light and noise, Noble will direct all lighting inward and downward and will utilize switches, timers, or motion sensors wherever possible to ensure lights are only on when necessary. There is also no permanent lighting planned on the well pads. In terms of noise reduction, the well pads will have no production equipment on them, resulting in less noise. And during completion operations, Noble will utilize a quiet frac fleet, which is specifically chosen to minimize noise levels. Next slide. And finally, to avoid and minimize impacts related to water, land, and site security, Noble's tankless facility design significantly reduces the potential for spills and leaks. Noble utilizes SCADA systems to allow rapid well shutdowns in case of any issues, ensuring quick response times to potential hazards. To maintain soil stability and manage water flow, Noble utilizes engineered drainage designs and implements necessary controls before and after seeding. Regular inspections are conducted using audio, visual, and olfactory methods to detect spills, leaks, and other contaminants. This proactive approach ensures that any issues are identified and addressed promptly. In summary, Noble's comprehensive efforts to avoid and minimize impacts associated with this OGDP demonstrate our commitment to environmental stewardship and operational safety. I'd like to thank you, commissioners, for your time, and I will now turn the presentation back to Kelsey for closing remarks.
Thank you, Tracy. So to conclude the presentation, I'll note just a few OGDP highlights. First, again, the proposed LG09 pad and expanded LG0903 pad are sited outside of all sensitive receptors and do not trigger any ALA criteria, thereby avoiding potential adverse impacts. The BMPs on the Form 2As further avoid, minimize, and mitigate potential adverse impacts. No public comments or petitions against East Pony were filed. The Weld County 1041 WOGLA permits are approved and recorded. And finally, the director determined that the East Pony OGDP complies with the commission's rules and recommends approval. Next slide. This slide shows the relief requested for the East Pony OGDP. And this does conclude our presentation. So we can take the PowerPoint down, and we do have a team of subject matter experts here on the panel and available for your questions.
Okay, great. See your subject matter experts. We have a panel before us. We've had a presentation. Commissioners, questions? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you for the presentation and for the, once again, the good quality of the work. I just wonder if you could talk a little bit more about the rig type committed to grid power with dual fuel backup. Can you elaborate a little bit on the conditions there? Do you have capacity already, the discussions with the power company, and give us a little bit more of a rundown of the feasibility since it's an as feasible request?
Yes, Commissioner Ackerman, I can take that question.
Mr. Merrick, before you speak, I don't think you've been sworn in yet.
If you could raise your right hand, state your name, and indicate that you swear to tell the truth, that would be sufficient.
Patricia Meinrich, I swear to tell the truth, and I'm sorry my video's also now stopped working.
No problem.
Yes, Commissioner Ackerman. So our intention and preference is to use electric power, and our rigs are all electric capable. We have secured grid power access, and the meters have been installed. The East Pony locations are at the end of the utility service line, and power is on a first come, first served basis. And so while our rig is electric, we may not always have the sufficient and reliable electricity to power the rig. And so if necessary, we will utilize the dual fuel to power the rig operations.
Thank you. That helps understand that you're kind of at the bottom end of the priority. Can you give us, do you have any more information on what the capacity of that power grid looks like and the feasibility that power will reach end of the line?
I don't at this time. I can take that offline and get an answer back to you.
Okay, just pausing to see if anyone else on the panel has any more insight on that.
Mr. Rouse?
Commissioner Ackerman, thank you for the question. We have we have commitments from the utility provider for the wattage that we requested for the rig to run the rig at full capacity. However, what Ms. Meinrich was trying to allude to is being at the end of the line, we may not always get the wattage that they committed to. That is our challenge. So they have committed to it, but we may not always get it.
Thank you. I appreciate that additional information. It sounds like you've got the equipment necessary and the commitment from the power company, but I understand that the operator can't commit from the power company ultimate delivery, and I understand that. And so if grid power isn't available, then you'll step down to, and I was a little unclear. It seemed like it was a tier 2 dual fuel. Is that natural gas and diesel supplement, or were you talking more about the natural gas and battery backup type rig?
Thank you for the question, Commissioner. That is a tier 2 dual fuel, as in diesel or natural gas optionality.
Thank you. And, that's I certainly don't have to tell you, you know more than I do, but that's a pretty good step down in emissions. Did you consider the other type of dual fuel rig with battery backup? And if so, can you elaborate a little bit on that consideration?
Yeah, I appreciate the question, Commissioner. We're in the process of upgrading our fleet with our rig contractors, and that is to be in place next ozone season, but not in time for these particular DPs.
Thank you. I appreciate the discussion and the considerable effort to work through grid power. Thank you for the progress that you're making on that front.
Other questions for the panel? All right, I'm on 2 screens, so if a commissioner that I can't see wants to raise a question, please go ahead and speak up, or we can move to deliberation. Anybody care to initiate deliberations? Commissioner Ackerman?
Thank you. I'd be happy to. And once again, I appreciate the discussion about grid power. We continue to move as an agency and as an industry towards best practices. This operator is a leader in that. I really appreciate their work on many fronts, even though I focused on the one question that I had. I think this is a very good application with a lot of best management practices, and appreciate the considerable work that's gone into it. I'm willing to make a motion, Mr. Chair, to approve this application.
Thank you for leading off, and thank you for the comments and questions. We have a motion. Do we have a second?
Second.
Motion and a second. Any further discussion? All those in favor indicate by saying aye. Aye. Any opposed? Motion carries. All right. Once again, we thank the applicant and staff for doing good work, getting us to a place where we felt good about the proposed OGDP. The next OGDP is a completely new set of folks, so let's take a few minutes. I need to take one other matter up real quick. Let's return at 1:24, and at that time, we'll take up the St. Oh, wait a minute. Hearings Manager Thomas, are you with us?
Yes, I am. St. Croix has St. Croix has graciously volunteered to continue their OGDP hearing to next week, so we can skip on to Wave Tech next.
Okay, we'll skip the Wave Tech next at 1:24. Thanks, guys. Okay, we're back. This is the Energy and Carbon Management Commission. It is 1:24, and we are taking up docket 231100340, an oil and gas development plan. Applicant is Wave Tech Helium, and we've got Ms. Wazelinski again.
Good afternoon. Our panelists are here. If they could just turn their cameras on, we can get sworn in.
Thank you. We'll start with Mr. I apologize for mispronunciation. Ebby, if you could raise your hand, state your name, and that you swear to tell the truth, please.
I am David Eby, and I swear to tell the truth.
Thank you, Mr. Bowen.
I am David Bowen, and I swear to tell the truth.
Thank you, Mr. Joby.
I'm Patrick Jobe, and I swear to tell the truth.
Thank you, Ms. Pfister. You're on mute.
I'm Miracle Pfister, and I swear to tell the truth.
Thank you. Mr. Gendelman. I'm sorry, Igor Gendelman, please.
I'm Igor Gendelman, and I swear to tell the truth.
Thank you. And Edward Gendelman, please.
I'm Edward Gendelman, and I swear to tell the truth.
Thank you. And Ms. Vogel?
Ms. Vogel's camera is not working. However, I think her audio should work.
Ms. Vogel, you are muted if you're trying to speak.
And you know what? We can get started. And if Ms. Vogel answers a question, we could perhaps swear her in later on.
Thank you.
Thank you. All right. Well, I think we're ready. We'll just pull our PowerPoint up and then I will get started. Wonderful. Well, good afternoon again, commissioners. My name is Kelsey Wazelinski with Jost Energy Law, and with Jamie Jost, we represent Wave Tech Helium in the first Wolf Helium OGDP before you today in docket 2311-00340. We would like to thank Cheyenne County for their support of the OGDP and also ECMC staff and the director for their efforts on this OGDP. Next slide, please. This OGDP requests approval of an approximate 641.1 acre oil and gas development plan for the development of 2 new vertical wells to target helium gas in the Morrow V3 sandstone formation. The 2 requested Form 2As are for the #1 WaveTech First 1233 pad and the #1 WaveTech Wolf Trust 43.5 pad as shown on this map. The application lands are unspaced and subject to Rule 401A, which provides that a well completion 2,500 feet or greater below the surface will be located not less than 600 feet from any lease line and not less than 1,200 feet from any other existing or permitted well completion in the same common source of supply. WaveTech owns 100% of the leasehold interest in the application lands and will drill and develop the proposed wells in accordance with Rule 401A. All gas produced from the Morrow Reservoir will produce directly to the existing Ladder Creek pipeline system. WaveTech does not expect to produce oil as part of this development. The two proposed locations are within Cheyenne County. Cheyenne County does not regulate the siting of oil and gas locations. However, WaveTech has been in close communication and consultation with Cheyenne County throughout the OGDP process and has the county's full support. Both locations are outside of the Lesser Prairie Chicken Estimated Occupied Range and are not in Rule 309 consultation habitat or HPH. WaveTech will discuss the siting and protective BMPs to minimize potential impacts from the proposed helium development in the presentation today. I do want to take just a minute to address the two conditions of approval, or COAs, contained in the director recommendation. The first COA states, after topsoil sample results have been returned, the operator will submit soil test pit data to ECMC via Form 4 Sundry not less than 30 days before the start of construction. WaveTech agrees to this COA. The second COA states, WaveTech will field verify the ordinary high watermark of a nearby ephemeral water feature and will submit an approved 1202A3 CPW waiver for the number 1 WaveTech Wolf Trust 43.5 location, Form 2A document number 403-444-544, to ECMC via Form 4 Sundry not less than 30 days prior to the start of construction. When WaveTech initially planned these locations, no wetlands or ordinary high watermark were observed at or near the planned Wolf Trust location. The Rule 1202A3 waiver was triggered by temporary drilling fluids consisting of water-based mud and a fuel tank that are planned to be stored at the location only during drilling operations and located within 500 feet of the nearby ephemeral water feature. WaveTech will not locate any permanent storage within 500 feet of this nearby ephemeral water feature. WaveTech conducted a recent field survey of this drainage, and it was confirmed through field verification that no wetlands or ordinary high water mark are present at the Wolf Trust drainage. WaveTech communicated the results of the field verification to ECMC staff and CPW. WaveTech does agree to this COA language and will submit the Rule 1202A3 waiver to CPW, but I did want to provide some background information on this COA request. And finally, WaveTech has complied with all notice requirements for the OGDP, no formal petitions were filed, and no public comments were received on the Form 2As. So I'll now turn it over to Igor Gendelman, the Vice President of WaveTech, to continue the presentation.
Thank you, Kelsey. Good morning, Commissioners. My name is Igor Gendelman, and I'm the Vice President of WaveTech Helium. I appreciate the opportunity to present the first Wolf Helium OGDP. Next slide, please. As we have mentioned in our previous hearings, helium is an essential element for many essential industries, and there are substantial reserves of it in southeastern Colorado. WaveTech staff has a lot of geological and operational experience and knowledge in this area, and we are leveraging it in our efforts to produce more helium. Next slide, please. This slide is to update you on permitting and operations. OGDP number 1 was approved on May 24th, 2023. This well has been drilled and is producing into Ladder Creek helium plant pipeline. To our knowledge, this was new helium production in Colorado in many years. OGDP number 2 was approved on November 13th, 2023. Burlington Farms 3211 well has been drilled and waiting on completion. Rhoda 3110 has been drilled and is producing into helium plant pipeline. And we're waiting on permit for Burlington Farms 43-2. OGDP number 3 was approved on December 13th, 2023. Harker Family 3122 has been drilled and is being tested. Hillman Family Trust 4215 permit has been approved, awaiting drilling. OGDP number 4 was approved on January 10th, 2024. 2 permits have been approved, and we're working on the third one. Next slide, please. OGDP number 5 was filed on January 17th, 2024. Completeness is expected this month. OGDP number 6 is the one undergoing a hearing right now. If approved, we expect to drill these wells in 2025. Next slide, please. OGDP number 7 is to be filed soon. If approved, we will drill these wells in 2025. And OGDP number 8 and 9 are to be filed soon. Next slide, please. This slide shows all of our 9 OGDPs. As you can see from the map, they're all next to the helium plant pipeline. Next slide, please. This is an overview of the first 1233 pad location. We plan to drill 1 conventional vertical well at this location, targeting helium-containing natural gas. All the gas production will go to an already existing Ladder Creek plant through an already existing pipeline system. This location is fee surface and fee minerals, with total drilling pad disturbance of about 3.5 acres. This location is not in the Lesser Prairie Chicken estimated occupied range and connectivity area, and no CPW consultations or ALAs are required. This location is more than 2,000 feet away from all residences, buildings, and schools. Next slide, please. This is the overview of Wolf Trust 43-5 pad location. This location has the same bullet points as the previous location. Next slide, please. Targets for both wells are more of fluvial channel sandstones. The reservoir is highly permeable and is part of a separate gas accumulation. The application lands are unspaced and subject to Rule 401A. WaveTech owns 100% of a leasehold interest in application lands and will drill and develop the proposed wells in accordance with Rule 401A. Next slide, please. This is the permitting timeline. WaveTech will continue to work with ECMC staff on process improvements for improved completeness timing. Next slide, please. This shows phases of operation. Pad construction will take about 4 days per location. We will drill 2 new wells. This will take about 14 days per well. Basic production equipment will be installed if the wells are productive. All the gas will go into an already existing pipeline. Next slide, please. Best management practices matching all the ones for our previous OGDPs will be used for these locations. And now I'll pass this presentation on back to Kelsey.
Thank you, Igor. To summarize the first Wolf Helium OGDP and WaveTech's request for approval, WaveTech cited both locations outside of CPW consultation habitat, outside of HPH, and outside of all ALA triggers to avoid, minimize, and mitigate potential impacts to sensitive receptors. No petitions or public comments were received on the Form 2As, and the director recommends approval of the OGDP. And finally, WaveTech agrees to both COAs in the director recommendation, which are shown in bold here. Next slide. This slide again just shows the relief requested for the first Wolf Helium OGDP. This does conclude our presentation, so we can take the PowerPoint down and all of our witnesses can have their cameras on and we are open for questions.
Thank you for the presentation. Appreciate the witnesses visualizing themselves. And once again, commissioners, we have a panel that is open for questions. Commissioner Ackerman.
Thank you. Predictably, my question is on the CPW waiver, and wanted to first get some clarification. I didn't understand very well. It sounded to me like in the presentation, it was stated that the wetland was the result of drilling fluids on site. Can you, I must have misunderstood that. Can you elaborate on that first, and then I'll have a follow-up?
Thank you, Commissioner Ackerman. And I can start this and perhaps Ms. Pfister can continue as well. The 500-foot trigger for the waiver was based on a temporary storage of drilling fluids at the location. So that statement was simply to clarify that WaveTech does not intend to store permanent chemical storage within 500 feet.
Thank you for that clarification. I appreciate that. So this is a bit of an anomaly. Normally we have CPW waivers in place before it comes before us. And so I guess my question would be, CPW certainly is under no obligation, even if we approve this OGDP, to act in any different way than they would normally in assessing and addressing this waiver request. Can you talk a little bit about if this waiver request is not granted, do you have a path forward, and what are your thoughts there?
Thank you, Commissioner Ackerman. So we did have discussions with CPW, and again, Ms. Pfister can address those as needed. We do understand that CPW is under no obligation to approve the waiver. However, based on the recent field survey results, we understand that CPW, and again, I don't want to speak for CPW, but that they're comfortable with the waiver because no ordinary high water mark was found at the ephemeral drainage. And at this point, comfortable with the COA language. So Miracle, I'm not sure if you have anything else to add to that.
The only thing I would potentially add is in talking to CPW, they outlined the information they want to see in the waiver and also stated the same that, they have to review the waiver in order to make sure they can approve it. So it's not a guarantee. So WaveTech understands that.
And Commissioner Ackerman, perhaps the alternative there is if the unforeseen circumstance that the waiver is denied, we would obviously find another location for that temporary storage.
Thank you. I appreciate that. And with that waiver in place, certainly it provides a safeguard, and appreciate the discussion there. I don't have any further questions, Mr. Chair.
Others with questions for the panel? Moving to deliberations, does anyone desire to start deliberations this time? Commissioner Messner?
I'll just move approval of the application as presented with the conditions of approval that were part of the director's recommendation.
We have a motion. Do we have a second?
Second.
Motion and a second for approval with the COAs as recommended by the director's recommendation as part of the motion. Is there further discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? Motion carries. All right. We've got one more matter before us this afternoon. It is the Bison operating OGDP docket 2403-00061. This looks like it is Ms. Wazelinski as well, or maybe it's Ms. Jost.
It's me.
Oh, okay. Are you bringing your witnesses on board?
Yes, they're aware that we're being pulled up right now. I believe that Weld County would provide comments at the outset.
You ready for me to kick off, Chair Robbins?
Yes, please.
Okay. Thank you again, commissioners, for allowing me the time to speak this afternoon regarding our 1041 WOGL process in regards to Bison 4 Operating LLC's Benelli 12 oil and gas development plan. On December the 6th of 2023, Weld County held a pre-application meeting for the Benelli location before you today. Attendees included Bison staff, Weld County staff, the ECMC, CDPHE, and CPW. The 1041 WOGLA application was received on March 13th of 2024. Weld County did not receive any public comments or applications for intervention regarding this application. The 1041 WOGLA hearing was held on June 27th of 2024. The hearing officer considered testimony at the hearing and then elected to continue the hearing to July 25th of 2024 to allow time for requested revisions to the drainage plans to be completed. The application was ultimately approved at the July 25th hearing. From a land use perspective, this is a good location close to other oil and gas developments intermixed with agricultural and commercial uses. The final order was recorded with Weld County Clerk and Recorder and was noticed in the Greeley Tribune on August the 9th of 2024. Approval of Bison's application creates a vested property right pursuant to Article 68, Title 24 of the Colorado Revised Statute. 2A comments were submitted to the ECMC and are included in the director's recommendation. Weld County agrees with the director's recommendation and supports approval of Bison 4's Benelli Oil and Gas Development Plan. And those are the comments I have prepared for you. I would be happy to answer any questions.
Thank you very much. Once again, we appreciate your participation. Do we have any questions for Ms. Holliday? All right, seeing none, we will allow you to move into whatever you're doing next. And thanks again for spending part of your day with us. And Ms. Wazalinki, you're recognized with your witnesses. Do we need to swear them in?
We do. Thank you, Chair. We just have 3 witnesses.
Thank you. I'd ask the witnesses to visualize themselves, please. I'm going to ask you to raise your hand, state your name, and that you swear to tell the truth. I'll start with, again, apologies for mispronunciation, Ms. Gillen.
My name is Katie Gillen, and I swear to tell the truth.
Thank you, Mr. Meyer.
My name is Bennett Meyer, and I swear to tell the truth.
Thank you, Mr. Hogan.
My name is Ian Hogan. I swear to tell the truth.
Thank you.
Thank you. We'll bring our PowerPoint up, and then I will get started. This is always the trickiest part, so thanks for your patience.
Did that not come up?
No, we don't see anything. There we go. All right, I think we just need it in presentation mode. There we go. Okay, well, good afternoon again, Commissioners. Kelsey Wazalinki with Jost Energy Law, and with Jamie Jost, we represent Bison 4 Operating LLC in the Benelli 12 OGDP before you today in docket 2403-00061. Again, we'd like to thank Weld County for its support and participation in the WOGLA process for the Benelli 12 OGDP, and also ECMC staff and the director for their efforts on this OGDP. Next slide. This OGDP requests that the Commission establish an approximate 1,920 acre drilling and spacing unit for the development of 7 new horizontal wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. The OGDP requests that the Commission approve a new Form 2A for the new Benelli 12 pad for the development of 7 new horizontal wells. As stated by Ms. Holliday, the proposed location is in Weld County, and the 1041 WOGLA permit was approved in July of 2024 and recorded in August of 2024. 1 Rule 304B2 ALA criteria applies to the proposed Benelli pad for the Rule 1202D pronghorn winter concentration HPH. Bison will discuss its alternative location analysis and CPW consultation in the presentation today. As part of the Benelli 12 OGDP, Bison has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Bison will describe today. To highlight a few, Bison is planning on a Tier 2 dual-fuel drilling rig with battery assist, Tier 4 engines for completion, and has committed to oil, gas, and produced water way. And finally, Bison has complied with all notice requirements for the Benelli 12 OGDP. No formal petitions were filed and no public comments were received on the Form 2A. So I'll turn it over to Katie Gillen to continue the presentation.
Good afternoon, Chairman and Commissioners. Thank you for the opportunity to present our application. We appreciate your time and attention. My name is Katie Gillen. I am the Vice President of Regulatory Affairs and EHS at Bison. Joining me as panel members are Ian Hogan, Bison's Executive Vice President of Exploration and Geology, and Bennett Meyer, Land Manager at Bison. Next slide. Here is a summary of the permitting timelines for this application. The 1041 WOGLA pre-application meeting for the Benelli 12 was held on December 6th of 2023. CPW, ECMC, and CDPHE expressed no opposition to the proposed location. The WOGLA was approved on July 25th, 2024, and there was no public comment received. Bison obtained the director recommendation for approval for this OGDP on September 4th. I will note there are no federal minerals that will be developed in this OGDP. Next slide. The Benelli 12 is located in Section 12 of Township 7 North, Range 60 West of unincorporated Weld County. Minerals in Section 12, 13, and 24 will be developed. There will be 7 3-mile lateral wells drilled from the north to the south. 16 acres will be disturbed for the construction pad, which will be subsequently interim reclaimed to 5.83 acres. The facility will be equipped with necessary oil and produced water storage tanks. However, Bison is proposing to reduce our original tank count from 5 oil tanks down to 4 oil tanks, and from 5 produced water tanks down to 2 produced water tanks. These tanks are necessary to ensure the facility's operation and to meet pipeline specifications. Bison is proposing a reduction in the original proposed tank count as we were recently able to improve our production estimates based on production data of Bison's nearby wells, which came online this past year. At the time of the application submittal, we had anticipated significantly higher peak produced water volumes as these were our first proposed 3-mile lateral wells. However, new production data from representative wells has allowed us to further refine our projections and therefore reduce our produced water tanks. Regarding the reduction in the 1 oil tank, we increased the size of our LACT, which is our lease automated custody transfer equipment, due to the 3-mile lateral well projections. This larger LACT will process higher volumes to pipeline. Therefore, we are able to eliminate 1 hydrocarbon tank. Upon approval of the OGDP and prior to construction, Bison will submit a Form 4 to reduce our tank count to reflect these proposed changes. Next slide. We have included a map depicting the cultural features under Rule 304B2B to highlight the remote nature of the location and how this location avoids most ALA criteria. The Benelli 12 pad avoids residential areas, high occupancy building units, disproportionately impacted communities, and matches the surrounding existing land use. The nearest waters of the state are over a mile away from the location. The nearest 1202C, no surface occupancy habitat, is over 3 miles away from the location. The pad is, however, within the 1202D density habitat for the winter pronghorn concentration area. However, Bison, along with CPW, sited the pad close to existing fragmentation to minimize and reduce further habitat fragmentation and CPW approved Bison's wildlife mitigation plan and did not have any objections with the wildlife components of our application. Finally, this location provides ideal access to the underlying minerals as well as existing pipeline infrastructure and has close access to Highway 14. Next slide. Bison performed an alternative location siting analysis as required under Rule 304B2 due to the location being sited in the winter pronghorn concentration area. Bison evaluated 6 other possible locations. The 6 alternative locations were identified in concert with the Weld County's pre-application meeting and the CPW on-site consultation that occurred January 23rd, 2024. Due to the disposition of the targeted underlying minerals, it is infeasible to develop the DSU from any location wholly outside of the 2024 mapped high priority habitat. Therefore, the alternative locations were evaluated with CPW's goal to maximize the amount of unfragmented habitat and to reduce impacts on wildlife. The first alternative location is in the northwest corner of section 12, shown in the light blue, just to the left of the proposed Benelli location on the map here. CPW had proposed this alternative. It was determined that this location would not, in fact, reduce fragmentation, as it is technically infeasible to fully develop all the minerals within this DSU due to the significant step out of nearly 1 mile to the landing point, which is technically infeasible for bison when drilling 3-mile lateral wells. Development from this location would necessitate a second location that would also need to be sited within high priority habitat to access the minerals in section 24, which would result in increased impacts to wildlife habitat. Furthermore, this alternative location would need to be located 250 feet from the western section line to avoid the mule deer habitat shown on the map in the shaded yellow, which would negate any possible benefits of reduction of habitat fragmentation and impact an additional species. The second alternative location in section 36, township 8 north, range 60 west, shown on the map to the far north. Similar to the first alternative, it was deemed that this location would present technical infeasibility to develop a 3-mile lateral well from this location due to the significant 1-mile step out. Similarly, this location would result in increased fragmentation of the habitat. To fully develop the DSU as a second location would also be required to access the minerals in section 24. Additionally, the surface is owned by the state of Colorado, which is generally less supportive of granting an SUA for off-lease operations. Additionally, there is a mapped hydrology feature within 2,000 feet of this alternative. The third alternative location is shown in section 24, township 7 north, range 60 west, and is the southernmost location depicted in dark blue on the map. The same set of facts regarding technical infeasibility and increased habitat fragmentation to fully develop the DSU applies to this alternative, as did the first and second locations. Additionally, there is a residential building unit about 2,239 feet as compared to the proposed alternative or the proposed location, which is over 1 mile away from a residential building unit. and over 4 miles of new pipeline would be required to connect this location to gathering infrastructure in comparison to the proposed location. The fourth alternative location is in section 12. Section 1, Township 7 North, Range 60 West. This location was not preferred by the surface owner as there would be heavy impacts to the cropland, which is the current land use. The surface owner stated this portion of the crop field typically produced higher yields and was unwilling to grant an SUA for this location. The fifth alternative location is in the northeast-northwest section, 12, Township 7 North, Range 60 West, and is shown on the map directly adjacent to the proposed Benelli pad. The topography had more challenging drainage conditions in this area and would require overall surface disturbance larger to accommodate the detention pond, which would defeat the intended result of reducing surface disturbance and fragmentation. In conclusion, the proposed location for Benelli 12 best achieves CPW's goal to maximize the amount of unfragmented habitat and to reduce impacts on wildlife, as well as addressing the other ALA criteria and sensitive receptors. Next slide. Bison worked with CPW to identify measures to reduce fragmentation and to address CPW's primary concern of truck traffic during the pronghorn winter concentration area from January 1st through April 30th. CPW found bison's avoidance, minimization, and mitigation measures to be protective of wildlife resources, in addition to the BMPs listed here, which bison has committed to. These include bison will install a 16-foot full wrap sound wall for pre-production operations that occur during the STIP. Bison will have 3-phase takeaway pipelines for oil, natural gas, and produced water, as well as a temporary lay flat for freshwater and on-site freshwater storage. The vast majority, well over 50% of drilling and completions will be completed outside of the pronghorn winter season, which mostly addresses CPW's concern about truck traffic during the winter season. While a majority of pre-production operations will likely occur outside of the seasonal timing window, Bison has also agreed to pay compensatory mitigations for both direct and indirect impact fees for operations that occur within the STIP. Next slide. In addition to the BMPs Bison has committed to during the CPW consultation, I would also like to highlight the avoidance, minimization, and mitigation measures. The pad and access road construction phase will be wholly outside of the pronghorn winter season, and Bison plans to start drilling in September of 2025 and anticipates drilling will be completed by the end of November of 2025, and completions are anticipated to be completed in very early January of 2026. To further reduce truck traffic during the flowback phase, Bison will implement our modern flowback design by turning flowback directly to the production facility, eliminating truck traffic needed for hauling flowback water for disposal. And finally, as noted before, Bison has agreed to pay both the direct and indirect mitigation fees for operations that occur during the winter concentration area season. Next slide. Bison has included best-in-class BMPs to avoid, minimize, and mitigate impacts during the drilling and completions phase. To highlight a few, given there are no nearby receptors for odor, Bison will utilize Group 2 drilling mud, which has a reduced emissions profile, shortens drilling time, and therefore time on location, which further minimizes drilling emissions. Bison worked with Morgan County, the power provider in the area, to try and obtain utility line power for electric drilling. However, Morgan County did not have the capacity necessary to serve the load for electric drilling. As such, Bison will still use best-in-class technology for drilling, which includes our compressed natural gas dual fuel Tier 2 battery assist engine. Bison will also use Tier 4 engines for completion operations and a quiet frac fleet to reduce noise impacts on wildlife. Next slide. During the production phase, Bison will implement the following BMPs. The facility will be equipped with oil, gas, and produced water pipelines. The production equipment will be powered on utility line power. The storage tanks will be equipped with tank vapor recovery equipment, which provides 100% capture and control of tank vapors during operation, and automatic tank gauging, which eliminates the need for manual tank gauging and opening the thief hatch, thereby eliminating those associated emissions. Bison implements a daily AVO and an LDAR inspection, along with the continuous emissions monitoring required under Reg 7. Next slide. Pending permit approval, Bison is planning on the following development timeline. We will begin pad construction in early August 2025. We will start drilling in September of 2025, and we will finish drilling and start completions in November of 2025, and we anticipate first production in early January 2026. Bison intends to fully develop the DSU in a single occupation. Next slide. In conclusion, there was no opposing public comment received on the OGDP or the 1041 WOGLA. We have local siting approval from Weld County. Bison worked with CPW and the surface owner to site the location to reduce fragmentation and impacts on wildlife. CPW approved Bison's wildlife mitigation plan and did not have any objections with the wildlife components of our OGDP application. ECMC staff, in their director recommendation, found impacts to public health, safety, and welfare were largely avoided, minimized, and mitigated by the successful implementation of our site-specific BMPs. Next slide. Hand it over to Kelsey.
Thank you, Katie. So the Benelli OGDP does contain a spacing request to vacate an approximate 640-acre unit and a 1,280-acre unit and establish a new unit for 7 horizontal wells from the Benelli 12 pad. The spacing application is summarized on this slide and is supported by land, regulatory, geology, and engineering testimony. Next slide. To summarize the Benelli 12 OGDP and request for approval, I'll note again that the 1041 WOGLA permit has been approved by Weld County. No comments were submitted on the 2A, no formal petitions were filed, and the director recommends approval. The OGDP triggers 1 ALA criteria for Rule 1202D HPH, and Bison has agreed to minimization and mitigation measures in collaboration with CPW to protect this habitat. And finally, after conducting a robust ALA, Bison has determined that the siting of the proposed Benelli 12 location best avoids, minimizes, and mitigates potential adverse impacts compared to alternative locations. And with that, we respectfully request approval of the OGDP. This does conclude our presentation, so we can take the PowerPoint down and we are open for your questions.
Very good. Thank you for the presentation. Commissioners, we have a panel available for questions. Commissioner Ackerman?
Thank you. Appreciate the presentation, and thank you for great work and a lot of great practices on many fronts on this application. A lot of good things contained in this. I do have a couple of questions or concerns as this is within Pronghorn Winter Concentration Area. And so the first one, just would like some clarification on the sound walls. Is the intent to keep the sound walls up, erect them before the winter timing season and then leave them up through the winter timing season? Is that what I heard?
That is correct. And we are anticipating a very short amount, I guess, of completion operations to occur in the first week of January. However, we would have the sound walls up before the STEP and would be taken down upon completion of our pre-production operations during the STEP.
Thank you. And that was my second question. And so you expect completion, you're starting in November and you expect completions to occur potentially through just the very beginning of January.
Yeah, that's correct.
Okay, thank you. And any thought to starting just a little bit earlier and keeping out of that season altogether?
We certainly would try. However, this was I think, conservative application. So it is very dependent on how quickly we are able to finalize the drilling operations on the previous pad.
Thank you. And I understand the fluid nature of that as well. One of the things that really caught my eye in this application from that perspective was that the vast majority was a term used a number of times. And that sounds like what you're explaining in your presentation as well today, but the vast majority in the documentation was qualified with a number of 50%, which objectively is nowhere near the vast majority of anything. And so would you be comfortable recognizing that 50% is not the vast majority and that the vast majority is what we're talking about here today?
Yes, I would. And that 50% number came from CPW. And so the CPW consultation included that number. So I think it's correct to say that, the vast majority, all of drilling in this case, and only about a week's worth of completions operations would occur within the STEP.
Thank you. And again, thank you for the further discussion there. I'm certainly comfortable recognizing that any work that's done within that winter timing period, as noted in your wildlife plan and the other materials, is subject to mitigation payments as well.
Yes.
Thank you, Mr. Chair. That's all I have.
Thank you for the questions, Commissioner Messner.
Thank you. So I wonder if it appears that there's some confidence that you're going to be able to complete this within the first couple of weeks of January. It would give me less heartburn if we could have a solid date for when the timing stipulations was going to start, rather than kind of the vague notion of the term vast majority. And so, is there more concrete dates that we can talk about timing stipulations, even if it's the 15th of January, through the winter season? And I think that creates a pretty solid, commitment to avoiding, and arguably would potentially eliminate the need for compensatory mitigation, or at least significantly minimize it. And so I wonder, and I'm not trying to do CPW's job for it, but I still am scratching my head here a little bit, as to the timing of this all and the determination for kind of a payment in lieu of entering into the timing stipulation. So I don't know if there was any conversations about that with CPW.
Yeah, we had fairly extensive conversations on this topic, which I think is why we ended up with pretty robust VMPs and agreeing to pay both indirect and direct compensatory mitigation fees. The challenge is, we don't have 100% control over executing the drilling exactly as, we would hope. There's always, some possible delay in those operations and, some things out of our control. And so we can't agree, I think, to a hard no operations within the STIP. However, I think we've made a great effort here to do so, to avoid the STIP to the extent we feel confident we are able to.
Thank you for answering my question.
Further questions? All right, I'm not seeing further questions, which means we potentially move into the deliberation stage. Commissioner Ackerman?
Thank you, Mr. Chair. And as I mentioned, this application does contain a number of great practices. I wanted to note that I appreciated the inclusion of dual fuel battery backup rigs, quiet completion, the active reduction of tanks during this process, that there aren't RBUs nearby. It's not within IDIC. They've proposed lay flat freshwater lines, 3-phase takeaway, including that no trucks will be needed for the initial produced water surge because of the capacity in their line. The full wrap sound wall, a single occupation, and working with CPW on a number of concerns, including fragmentation and HPH concerns, together with direct and indirect mitigation. I agree with Commissioner Messner that it would be certainly ideal, I think, for all involved if you are able to accelerate the timeline a little bit and complete entirely by the end of the year. I am comfortable with the vast majority. I think the vast majority is generally well understood as almost all. And so I'm comfortable with that terminology, so long as we have an understanding that I'm not recognizing the 50% number as the vast majority. Those are my initial thoughts, Mr. Chair.
Others with thoughts? Commissioner Messner?
Commissioner Ackerman, I certainly appreciate your expertise and your thoughts on this. And so, inevitably defer my opinions on this to you and to CPW and their determination. I will just state that this does not sit with me, particularly in the consideration for the compensatory mitigation, the direct compensatory mitigation really being utilized, I think, as a clear payment in lieu in this situation. And I'm not sure that the avoidance piece of the mitigation hierarchy truly got applied in this particular situation. And at the same time, if CPW, which is our wildlife expert, has determined that they're comfortable with it, then I don't really have a foot to stand on as far as making any different determination, but it doesn't sit right with me. And so I just will indicate that.
Further thoughts? Anyone desire to make a motion? Commissioner Ackerman?
Thank you, Mr. Chair. I will make a motion to approve.
Motion, was that a second?
Yes.
Very good. Motion and a second. Further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thanks again, Ms. Wasilenki. Appreciate the work here. Appreciate, again, the work from staff. The OGDP is approved, and I believe, unless Mr. Thomas corrects me, the business of the agenda is now concluded.
That's correct, Mr. Chair.
Okay. All right. Well, commissioners, I think we have a few hours of the day left to get ready for tomorrow's hearing. To the world that's listening in, our cumulative impacts and enhanced systems practices starts again tomorrow morning at 9 a.m. via Zoom. We hope that you will join us as we continue to work through the correct place for our state in those important matters. So thanks, everybody. We will see you in the morning.